2022 hearing for the Planning and Land Development Regulation Commission is now called to order. And if I could please have you silence any audible devices that you may have, phones, laptops, or whatever. And if you could join me for the Pledge of Allegiance. To the flag of the United States of America, to the republic, Good morning, everyone. I'd like to thank everyone for joining us this morning. Those of you who are in the chambers and those of you listening on the PLDRC webinar. Ms. Ray, could I please have the roll call?
Member Feller?
Here.
Member Young?
Present.
Member Shelley?
Here.
Member Costa?
The broadcast is now starting. All attendees are in listen-only mode.
I'm still here.
Member Sixma?
Here.
Chair Mills?
Here. Thank you, Ms. Ray. You didn't say Mr. Bender.
I'm here.
Mr. Bender?
Okay. Thank you so much. And we do not have any minutes for discussion this morning, so I'll move right on into it and say if anyone would like to speak to any of the cases for or against any of the cases being heard today, if you could please fill out a form in the back of the dais here and hand it to Ms. Ray to my immediate left. And when it comes time to hear the case, we will have you add additional comments if you'd like. We will be limiting you to a 3-minute time limit, though. And after the comments have been heard, I will give the applicant an opportunity to address any concerns the speakers have and answer any questions the commissions may have. And at this time, I'd like to turn it over to Mr. Sawyer for legal comments.
Thank you, Mr. Chair, and this is for the members of the public as well as applicants that decisions by this body on special exception cases and cases which rezone real property from one classification to another pursuant to the zoning ordinance are recommendations only to the county council and do not constitute a final hearing. So new evidence may be introduced at the county council public hearing. Decisions on variances made by this body constitute final action subject to an appeal to county council. And what this means is that no new evidence may be presented at the time of the county council public hearing on the appeal. An aggrieved party that appeals such a decision is confined to the record made before this body. So all the evidence needs to be provided here. Hearings by this body on rezonings, special exceptions, and variances are quasi-judicial in nature, meaning that this body is acting more like a court and must take into account all oral, written, or demonstrative evidence presented. Their decisions on these cases must be based on competent substantial evidence in the record, and competent substantial evidence has been defined as that evidence a reasonable mind would accept to support a conclusion. Thank you, Mr. Chair.
Thank you, Mr. Sawyer. And while on legal comments, I'd like to ask the commission to disclose for the record any ex parte communications that have occurred before or during the public hearing at which a vote is to be taken on any quasi-judicial matter. And I'll start to my immediate right with Mr. Feller.
I have none.
I have one email from Dr. Wendy Anderson on the case 022-135 that I received. That's all.
And that
That is
you
part
can
of
disclose
public
it, but that's not a quasi-judicial item, so
Okay.
yeah.
Yeah, that's part of public record. I think that's part of our record. Okay, Ms. Shelley?
None.
None.
And I have none. Okay. We do have an item to be, is it withdrawn or continued, Ms. Smith?
We have one item to continue. It's Z22-121. It's Barnes, and the applicant missed the due public notice requirement, so we're continuing it to the next meeting.
Okay, so that's a continuance to the next meeting,
Yes, sir.
which is September 15th. Okay. Okay, any discussion on the request or a motion?
I'll make a motion that we continue the September 15th meeting, case Z22-121.
I'll second.
Okay, I've got a motion from Mr. Sixsmith to continue case Z-22-121 to September 15th, 2022. And a second from Ms. Shelley. Any discussion on the motion? All those in favor signify by saying aye.
Aye.
Any opposed? Motion carries unanimously. All right, we're going to move right on into our new business. Ms. Shelley, could I get you to read the first case into the record?
Yes, sir. Case number V22-033, variance to the minimum yard requirements on urban single-family residential R9 zoned property.
Okay, thank you, Ms. Shelley. And Mr. Hanson.
Good morning, Michael Hanson from Planning Development Services. This particular variance, staff made a recommendation for the approval of variance V22033. We noted it met all 5 of the required criteria. Looking over the particular property, it is in the Bethune Beach area of New Smyrna Beach. It's zoned R9. The size of the property is approximately 5,000 square feet. There is one correction note in the background and overview. It mentions the exterior elevator to a south side yard. It's actually on the north side of the property, just to make sure everyone's aware. The particular area over in Bethune Beach is also part of the Indian River Lagoon Surface Water Improvement and Management Overlay Area, which requires on-site stormwater retention and native vegetation planting. The particulars of this variance request is for an external elevator on the north side of the property, as I mentioned, and I'll advance the PowerPoint so you can see there you go. But if you look on the variance site plan, you can see the proposed location of the exterior elevator. It impacts and encroaches on that north side setback, which was normally 7 feet for the R9 zoning classification of 1 foot. We did receive an email letter of opposition from the adjacent neighbor on the north side of the property, indicating the proposed elevator would be visible to their sight lines. The purpose for the elevator, as has been instructed to staff, is to support the residents of the property. The owner of the property is starting to develop mobility issues, and then her aging mother also lives on the property. So the design of the elevator is to allow them to continue access to the entirety of the residence. Staff evaluated all the criteria and ultimately determined that the variance request met all 5 of the criteria. I'll sit for any questions that the board may have.
Thank you, Mr. Hanson. Any question for staff? Is the applicant present? Can I get you to come forward, please? If you could come to the mic there. And if I could get you to state your name and address for the record?
Ann Rutledge, 6246 Ingram Road.
Okay, you've heard the staff report. Is there anything you'd like to add to that?
Yes, I would. I mean, I have a couple of pictures I would like to show also of the home next door. The people who live next door are vacationers. They live in Orlando. I'm a full-time resident. We built the house in '06 and have lived there since then. And had originally planned on an elevator, and then when I did some renovations last year and went to build the elevator, the specs were not what they should have been. So I'm not able to do it. Unfortunately, on the 3rd floor of my home is the master and the kitchen. So for me or my 97-year-old mother to access that has been hard. I am a single mother. I don't have any help carrying in groceries and all that. So eventually that might be a problem. I hope later than sooner. But I do have a couple of pictures of the home next door that I'd like to share with you. Their property is has been very overgrown. I understand the canopy and all that they're trying to preserve. But since we haven't had a whole lot of heavy storms in the last few years, the vegetation has just gone crazy. It used to be maintained with the level of the top of the house. Now it's just way up. For the first time that they've ever owned the home, about 2 months ago, they came in and had it all cleared out. Their trees actually used to tap on the window that the elevator is supposed to go into. So it's usually a very overgrown space. So since their window is a little bit visible right now, it usually is not. Usually you cannot see anything from my house to their house, and I'm sure that the vegetation will, continue to grow now that they've trimmed it back. But I do have a couple of pictures I would like to share.
Okay, if you have the pictures, you can give them to Ms. Ray to my left. They become part of the public record and you will not get those back. Okay? Okay, Ms. Rutledge, if you could, let's finish up with you and see if any questions of you, and then you can discuss that with her, okay?
Okay.
All right, any questions for the applicant? Okay, I don't have any. Let's see if we have any public participation. If we don't, we'll move forward with this and have a commission discussion, okay?
Okay,
Thank you so much.
thank you.
Do we have any public participation forms for this, Ms. Ray? Okay. Therefore, I'm going to close the floor for public participation and open up for commission discussion or a motion.
I have a question for staff, real quick.
Mr. Costa?
If, can we put up page 10 of 16, and then right after that, page 11 of 16? Just trying to get a perspective on.
One moment, sir, working on that. It was 10 and 11, did you say?
10, yeah, let's start with page 10 first. The picture on the bottom. So looking at that, it's the greenhouse, correct, that we're discussing?
Yes, sir.
Okay, and the elevator is going on the left or right side of that house?
The right side of the house, so that would be the north.
Okay, would you go to the next page then? So looking at that, the elevator is actually on this side, correct?
That
Of the
is
house?
correct.
And if you go flip back up to the top page, I'm trying to verify with what the letter that we have in opposition here, that the house next door is in fact where all those trees are currently pictured. Is that correct?
Yes, the picture on the top with the tree cover coming over the blue line is the side that we're looking
Okay,
at.
so there's really no house adjacent. It's actually almost behind their existing house, if I'm looking at this aerial correctly. That's all vegetation.
That is correct.
Is that right?
Their house is set back further, so their front area of their yard is covered with trees.
So the elevator shaft is actually adjacent to the vegetation, not necessarily the house itself.
Yes, sir, and that was part of the staff criteria recommendation of approval for criteria 5.
Okay, all right. That's what I needed, was that perspective. Thank you.
I have a question.
Mr. Feller?
Thanks, Chair. So I'm very familiar with this property because I lived right down the street from it. My concern would be that the property to the north owns from the street to the riverside. So it's a full-length lot as compared to some of these others. But if the homeowner to the north decided to build further towards the Ingram side, which they have a right to do based on setback, now we would be having house next to elevator shaft if we approved an elevator shaft there. Would that be correct?
Yes, in the R9 zoning classification, the front yard setback's 25 feet, so they could theoretically do an addition onto their house up to that 25-foot setback.
Which would then negate the vegetation.
That is correct.
So if we approve this, we would be basically then confining the property owner to the north to not being able to build, or if they wanted a 1-foot setback as well too, when then we would have nothing between the two, correct? I mean, I guess what I'm saying is, are we approving it here, but then limiting the property use of the property owner to the north?
That could very well be possible. However, one thing also to take into consideration, which I mentioned, because it's the R9 zoning classification, they're part of the Indian River Surface Water Improvement Management Overlay Zone. So they would be able to, on that adjacent property, clear the trees as long as they're able to still meet the requirements of that surface water improvement management overlay, so the 35% native vegetation, on-site stormwater.
It's a huge lot, so
Yes, sir.
I don't anticipate that being an issue, but I mean, I guess what I'm saying is I feel like we would be setting one property up to deny another property the ability to do, I mean, I know the house very well, so I know that the front yard setback and where it goes, if they wanted to square off the front of their house to be Ingram, they would then be left with an elevator shaft 1 foot from their property. Is that correct?
That is correct.
Alrighty. I actually did have a question for the homeowner. I'm sorry, is that a possibility to
Sure.
bring back up? I'm sorry.
Yes, and get the homeowner back. Mhm. Ms. Rutledge?
So when you said you did I know you did the updates, which it looks beautiful, by the way. Let me say, I love the house. It's gorgeous, the rope, everything.
Thank you.
When you did the updates, there were the two front decks. Was there ever an option of maybe putting the elevator shaft there where those front decks already currently met setback? Or is it that you wanted to have the front deck versus the elevator? I'm just trying to figure out, or what was it, a need then? I guess I
We had it originally planned to put on the side. It came in the house.
inside.
And
yeah.
then when we did the remodel, the shaft did not meet the specs. So we had to do away with that. So then I had to go to option 2.
When you
which
said
was-
didn't meet the specs, what do you mean? I'm sorry.
The shaft was not built to the specs that had now changed since we built the house for the elevator specs.
I guess what I was asking is, could you, at the time, I mean, either way, could it go where you have decking that's within your buildable area?
The only place I could really put it would be at my front, at the very front of
Which,
the house.
which I understand, and
Yeah.
unfortunately, on 50 by 100 lots, I mean, that's a big part of what's going on down there is there's not a lot of room to build.
Right.
And what I worry about is now everybody's building to 1 foot setbacks, and then we don't have setbacks. I mean, so I bring it up that way that, when I look at it, I know that your rear setback is also 5 foot, I believe,
Right.
on that. And it looks like there's room on the rear. And again, maybe it doesn't make sense in the house, but I feel like we're putting something where we are. And I'm just wondering, did you explore any other areas?
Well, there's no room in the back to put it now because I've been going through permitting for about 1.5 years for my pool. So there's nowhere to put it in the back, but on the side of the house, their house is actually set back a lot further than my house. Yes.
Right, the north corner is set back.
I can't see them building this way. They could maybe build, I don't know. They've got a beautiful back deck that they look over the Indian River. I would imagine that's most of their living space, with all the big windows in the back. I don't know. I don't know what their future plans are. It's a second home. Who knows how long they'll own it?
What I'm concerned about, though, is if they sell it and it becomes somebody's first home, then they don't have the right to do things. And that's basically what I was just to understand. So,
Right,
okay.
right.
I appreciate it. Thank you so much.
Mm-hmm.
Mr. Feller, in that line of questioning, the adjacent property owner has the right to apply for variance, doesn't necessarily mean that have the right to get one approved. And so there you would be an 8-foot separation between the buildings and the elevator shaft. So, I mean, each case needs to be looked at individually rather than to try to say, well, if we do it for this one, we got to do it for that one. No, they have the right to apply for it, but they don't have the right to actually receive it.
Well, understood very much. I do understand that, Chair. I'm just looking at, at the end of the day, the property rights considerations were, on one. So I bring it up that, I just look at it.
Okay?
Yeah.
Any other questions
Prepare to make a
for
motion.
discussion?
Prepare to make a motion?
Yes, sir.
I'd like to make a motion that recommend approval of variance case number V-22-033 with, I believe, the 2 staff recommendations.
Second.
Right. I've got a motion from Mr. Costa to approve variance V-22-033 with the 2 staff recommended conditions.
I'll second that.
No, I've already got a second from Mr. Sixma. For Mr. Sixma, any discussion on the motion? Hearing none. All in favor signify by saying aye.
Aye.
Any opposed?
Aye.
Okay, Mr. Feller, you opposed? Okay. Right. Motion carries 6-1 with Mr. Feller in dissent. All right, Ms. Shelley, could I get the next case, please?
Case number V-22-115, variances to minimum yard requirements on rural mobile home Mh6 zoned property.
Thank you, Ms. Shelley. And this is Mr. Sham. Where'd he go? Oh, there he is down there.
Good morning. I am Steve James with Planning and Development Services. This case is for 4 variances to reduce minimum yard requirements on the property. Variance 1 is to reduce the front yard from 40 feet to 20 feet. Variance 2 is to reduce the rear yard from 40 feet to 20 feet. And variances 3 and 4 are to reduce the side yards from 15 to 10 feet. Many parcels in the subdivision are non-conforming in size, and the county attempted an administrative rezoning in 2018. The residents didn't support this, so it was withdrawn. The lot is currently undeveloped, but has an unpermitted accessory structure in the rear. It's a barn. The applicant was notified he would need a variance and permit for the barn, but indicated he would remove it. The applicant wishes to establish a buildable footprint on the property with the intention of constructing a manufactured home, but he does not yet have a home picked out. He also indicated he wanted to construct a smaller shed and potentially a swimming pool. Staff is unable to determine if he can meet the 35% max lot coverage or whether additional variance will be required for future plans. In addition, there are 2 40-inch historic trees in the property, historic oak trees. The tree preservation ordinance prohibits construction inside of the drip line. This is a street view image of the property. There's the 2 trees in the center of the photo and the barn at the rear of the property. Both drip line areas cover 9,000 square feet, which is nearly half of the property. Granting setback variances to shift buildable area away from the trees may be justification for approval, but the applicant has not indicated a desire to shift the area to avoid impacts to the trees. Environmental staff calculated tree removal costs would be in excess of $20,000 if the DRC allows them to be removed. Staff recommends denial because the zoning ordinance would not prohibit the applicant from developing on the property. It only prohibits the buildable footprint. This is not the minimum variance because a detailed site plan was not submitted for thorough review, and granting the variance could result in significant impacts on the historic oak tree. We also submitted 3 conditions if the PLDRC finds evidence for approval.
Mr. Chair, we do have the county forester in the room if you have any questions for him as well.
Thank you so much.
In addition, we also received 1 letter of opposition from an adjacent property owner.
Okay.
And I'm available for comment.
Okay, any question for staff? Mr. Feller, let's start with you, or Ms. Shelley, go ahead.
I have a question. I meant to call in and ask this question. On staff recommendation, it says on each variance that they fail to meet all 5. However, in looking at the analysis, it states in my packet, variance 1 through 4 meets the first criteria and meets the second criteria, variance 1 through 4. So it looks like, unless there's a misprint or something, that they actually meet 2 of the 5. Is that correct?
That is correct. And we understand that may have been interpreted differently than it was intended. The intent was to make the recommendation more generic so that every time you all get these reports, you aren't seeing incorrect numbers. So it was intended to say that they don't meet all 5, not that they don't meet any, but we understand that, and we'll go back to inserting the number that they don't meet to keep it very clear.
Thank you.
Okay, any other question? Mr. Feller?
Mine is also kind of a question. On page 3, it says the request for the front yard to 25 feet and the rear yard to 25 feet, but then in the variance request it says 40 to 20, 40 to 20. Is it 20 or 25? Do we know?
I believe we received an updated site plan image, which is on the slide previous. That wasn't updated in the report.
So it is 20.
Yeah.
Okay. Just a note on page 3. So, thank you.
Okay, any other question? Mr. Bender?
Is there, when looking at the report, it basically states that staff did not have enough information to correctly evaluate this situation. But from what you all have seen, is there any scenario on this piece of property with those 2 trees not being disturbed that it can be developed?
I got it. Yeah, so looking at the property itself, there is a buildable footprint at the rear. If you were to, well, part of the issue is we weren't sure what he wants to build because there wasn't a detailed site plan submitted. He just wanted a footprint to build within. If you were to submit a specific home that we knew the dimensions of, you could accurately assess where it should be located. In all likelihood, a variance to the rear setback would be applicable here. It's just when we had this review, there was not enough information, so we couldn't approve a footprint to the center of the property.
Okay, so once the property owner come up and address it, it almost seems as if a continuance would maybe be the direction to go in order to give them an opportunity to go and come back with full information so that a decision can be made. That seemed like maybe the thing that you want to consider
That's
here.
in the discretion of the board of whether or not you want to take the information you have now and make a ruling on that, whether approval or denial, or grant the property owner the chance to come back with additional information through a continuance. You've done that previously.
Mr. Chair, I have a question
Mr.
as well for staff. What I'm missing here, this piece of the puzzle, is you're showing me a potential buildable footprint right here, but you don't show me on that buildable footprint the location of the trees and then the canopy requirement, which would then give me an idea of what areas would, as a novice, what area I would potentially put a house at. And if we're going to require additional setbacks on left and right from a commission standpoint. So right here, all you give me is a blank slate, and I'm looking at this going, well, all you need is a variance for the shed, put the house anywhere you want. Because now you're burying in this document that you got 2 historic trees, but you're not showing them to me on this diagram. And that's lacking from my perspective.
If I could just clarify, we did direct the applicant to our environmental permitting folks, and there have been very extensive conversations with our county forester about what he could potentially build and how we can help him get to a yes. Part of that is, in addition to the trees, if variances are for hardships, and we're having a very difficult time at this point because of the lack of information establishing the hardship until we know where the house footprint is.
So they're in conversations with forestry now to identify an actual footprint that he can work with?
That's my understanding.
Okay, thank you.
See, we have to establish our hardship, and
I mean,
obviously we can't do that.
well, I need, until I hear from the applicant, I really, at the moment, I can't weigh in one way or the other here.
Okay. Any other question for staff?
How can we grant then a location? I'm like them. I was looking at this earlier. I don't know how I can say this is where you can build, because if we say that, he's going to say, well, you gave me the okay to build there. I think we need to know some more information. As far as I'm concerned, I do.
Well, let's hear from the applicant, and maybe he can answer some of those questions. Is the applicant present? Yes, sir. Could I get you to come forward, please?
Morning.
Good morning, sir. Could I get your name and address for the record?
My name is Corey Romanek. I'm at 1893 Fairland Road, Ormond Beach,
forward.
All right. You've heard some of the discussion we were having on this. Would you like to address any of those concerns?
I'd like to submit 2 documents, if I could, for the record.
You can. Just hand it to Ms. Ray to my immediate left.
Two documents I just submitted. One was a non-conforming lot letter. I bought this lot from an attorney, Noah McKinnon, and his attorney, Jeffrey Sweet, is the one that prepared this non-conforming lot letter. I did a lot of due diligence prior to buying this property. I went to zoning, I went to the planning department, I went to the building permit, I went to the health department, I went to everything, and there's quite a few things that are not mentioned in this report. I bought the property in May of this year. In April, there was a mobile home already on the lot. So a principal residence was established. The person deceased, and I guess before they sold that lot to me, they had that mobile home removed. I provided a documentation and record that the tax office has record of that mobile home being there. As far as the trees, that's not a germane conversation here. And the reason why, if I do get to build a primary residence, all that zoning ordinance, DRC stuff gets removed, because once it becomes a primary residence, there's no more control over trees on that lot. I have the code number. If I'm required to read it, I certainly can. Additionally, in conversation with Ms. McFarland, I was told that this commission doesn't really have a lot of say in the trees, that would be a separate permitting process with DRC, and that my intent is to build a primary residence on this house, on this property. I don't have the plans because I was trying to establish the footprint, because as it is right now, my lot is 200 feet deep. I've got a 40-foot setback on the front, a 40-foot setback on the rear. That's that leaves me 120 feet of buildable space. My lot size, the sides, that's not a big concern, but being it's non-conforming, why am I being held to a setback restriction if you already have it identified as being non-conforming? The Mh6 is 40 feet, 20 and 20. I'm already showed a non-conforming issue. So that was the reason why that I applied for a setback variance. Now, I do plan on submitting full plans in location of what I would like to build. The purpose of my variance is just to get the allowable footprint of what I can build into, knowing that I'm going to have to work with the forestry division and go through DRC to talk about the drip line edge and to work with them where I'm not going to disturb. The reason why we bought that lot was for those trees. You can't find a home recently now where you've got some nice trees in the lot because they have been removed, or they're not fully grown, or you just can't find that. So my wife and I thought we bought a gem, quite frankly. We wanted to put our primary residence on. And with the way the property values are going in this county right now, we thought that might be the most economical way to proceed this, is to go ahead and buy a nice lot and then build on it and make it a primary residence. So, but I also disagree quite a bit with some of the comment regarding me not providing enough information. I went down and told them what I wanted to do. There was a peer review meeting prior to them accepting this case. I explained to them what I wanted to do. There was some questions, and what I told them, the only thing I'm trying to do is to get my variant setback set. I want to get that barn off my property, because if you could show the picture of that barn again, that's kind of the area of where I want to put the rear of the house. So I want to have the house set back, but that barn footprint's killing me right now, because I can't get back there to take an accurate measurement and survey of where I want to put that. On the left-hand side, and there's, by the way, there's 4 trees. There's not 2, there's 4. Left-hand side. And the original trailer was located in that ground clearing spot on the left underneath those trees. There's currently a septic line inside the ground in between those trees. On the other side of that large tree, in between the 2 trees, back about 20 feet, is a 100-foot deep well already in the ground. None of this has been permitted. The barn was not permitted, the well was not permitted, the septic was not permitted. And this is done back in the 80s when, I guess, people just did whatever they wanted to. I'm trying to get this thing tightened up and get it formed and get it going into a legal condition. So the reason why that I asked for the variance was to establish my sidelines, establish my front lines, get that barn out of there, hopefully go buy a storage lot, kind of where you buy a storage shed from a lot where they've got sheds, put it in the back corner, because in that barn right now I got a riding lawnmower and I got some yard equipment. So if I demo that barn, I won't have any place to keep my items on that property that I used to maintain that property. If you look, I try to keep the grass cut, I try to keep everything cleaned up on it. So I don't know. I just felt that, I spent a lot of money to get here between the variance fee and the advertising fee and the survey that I had to do, and then the certified letters going out, and the property right next to me that you see to the left is for sale. There's no running water on it. It's kind of an abandoned condition, so I'm not sure what the issue is, but the last thing that I would ever want to do is hurt those trees. And I've had this conversation with the forester. But once again, I feel that the concern with the historic trees is mentioned in section 5. That's not reviewable here. That's got to go to DRC.
Right.
And I plan on pursuing that thoroughly. And also, the forester has offered to sit down with me once I find out what I want to do and help me design something where that they would be negotiated regarding that drip line edge. But like I said, once I get my CO, my certificate of occupancy on that residence, all that forestry stuff goes out the window. It's not applicable, does not apply to an owner-occupied piece of property.
Right. Okay, Mr. Feller, you had a question?
I do. I have a couple questions for you. So you're saying building back by where that existing barn is.
Yes.
So I understand looking at a rear setback if you're doing that, but why we're looking at a front setback too, reducing a front setback. And you were talking about buildable. I mean, I was just doing the math. In the current setbacks, there's like 8,400 square feet buildable area.
Mm-hmm.
You can't find a place to put a house in 8,400 square feet.
I probably could, but it's a 40-foot restriction from the rear yard.
I get it, and that's part of why you've heard the other case
It's
before.
a non-conforming lot. I'm being held to a setback restriction based on an MH4 requirement.
I get it. And
that's
like
a 1 acre minimum.
Right.
So we have setbacks set on a half-acre lot that apply to a 1 acre lot.
Right. And if you wanted to keep the shed, I would sit here and say, okay, well, there's a shed existing and we should look at creating a variance. But what I'm saying is we don't have anything to look at here to say all we're doing is just increasing the buildable square footage of this lot without any reason to increase it. I mean, those are the setbacks. I mean, I understand you may not like them, but those are the current setbacks of the property.
There's a couple of reasons too. At first, I submitted a non-conforming lot letter, and you guys are holding me to a 1 acre.
That doesn't negate the setbacks, though.
Well, number two is the other thing is I applied for a variance with my reasoning of why I want to have the setbacks reduced.
Okay.
I want to increase my front yard and my side yard without having restrictions. If I want to put a shed back there in that back corner, I like to be within a certain amount of setback and not impede on my neighbors on that variance that's set there for them guys. So I mean, I'm trying everything I can to provide the information. I do want to build a single family home on this lot. I believe that I should have the right to have a conventional style lot like most people and most properties in Volusia. You're talking about a 1 foot setback where you live, sir. I'm asking for a 20-foot setback.
I know. I voted no on a 1 foot setback, so I get what you're saying.
I'm asking for 20 foot, which is reasonable compared to a conventional building lot in Volusia County. That's nothing unusual. My issue is that it's a non-conforming lot, and I'm being held to a setback that applies to MH4, which is a minimum acreage requirement of 1 acre. I have less than a half acre, so I'm trying to adjust my setbacks accordingly. If I have less than a full acre and I have a half acre, why can't we adjust setbacks to half, which is normal? So, and like I said, I know that there's a couple things in here. I mean, that anybody can deny anything that you want to go for. I got that. But I'm trying to straighten this out. I'm trying to get a home built on this property. I'm trying to get a legal well put in there, a legal septic system in there, and a legal barn in there, or a legal shed, as you will. I want to try to get all the other stuff off the property and comply. I want to be in total compliance and get this place straightened out. That's what I like to do. And I want to maintain the trees. I don't want to damage them.
if they haven't been damaged in the last 30 years from having a trailer there in the drip line and having a sewer system in the ground and a 100-foot well, I don't think that what I'm going to do outside that drip line is going to impact that area whatsoever.
Okay. If you don't mind, I would like to hear from the forester, and then I'll bring you back up if you don't mind.
Yes, sir.
Okay. Could I get the forester to come forward, please? Mr. Abrams, how you doing this morning?
I'm good, and you?
I'm doing good. Your name and your name?
Keith Abramson, Volusia County Forest.
Okay. You've seen the concern that the applicant has this morning, and if we were to approve a variance, how would that impact his request to get that reduced to the tree?
Be increasing the buildable area, which could increase the impact of the root.
Right.
The tree protection section of the Land Development Code 842 or 844 requires a tree protection zone of 1 foot per inch of radius. So I spoke with the applicant, and we're willing to work with him when he gets a house plan together. We can come up with a root zone encroachment plan with a certified arborist. Typically, the applicant would provide the tree survey. Why you don't see on it. You'd have a surveyor mark the trees, the root zone. We could come up with a plan, hopefully that doesn't encroach more than 30% of the root. Anything above 30% root zone encroachment would require DRC approval for the removal of.
My question is, if we were to approve this variance, would it in any way tie your hands just to enforce your tree ordinance?
The tree ordinance would still apply.
It would still apply.
Would
So
still
no
apply.
matter if we told him he could go, as large as we want on this piece of property, that it would not have any impact on him meeting the requirement of the tree ordinance. Am I correct?
Yeah, you're correct. He would still
Okay.
have to.
That's what I was trying to establish. Okay. Mr. Feller?
There was mention of, and I know the applicant said he wants to keep trees, but there was mention of after he makes it a single-family home, he no longer has any tree requirements. Is that correct?
Once the lot becomes owner occupied, he has the house there, he lives there, he has a CO. Tree exemption
Goes
section,
away.
exempt owner occupied lot.
So he could cut the tree down.
Technically, yes, but the thought is that once you go through all that process of saving the trees, moving the home, that the cost of removing the trees and all the work to save it.
But would it be outside of to build a portion in the set, call that set buildable home, remove the trees, and then continue to build all the way, yeah.
I have seen that.
Yeah. So,
Yes.
just something to bring up that, it doesn't have to be an 8,400 square foot single-family home to live in it. It just could be whatever the minimum lot requirements are. Then it's once buildable, those trees can be removed. They can continue to build into those sections after
It's owner occupied.
After it's owner
yes.
occupied. Okay, thank you for clarification.
Okay. Thank you, sir. Any other questions for the board? Okay, thank you. All right. Do we have any other questions for the applicant? Do we have any public participation for this?
No, sir.
Mr. Romanek, would you like to say anything else before I close the floor for public participation?
Excuse me, Mr. Chair. We did have one letter of opposition that did come in that you have in front of you.
Yeah. Okay. All right, Mr. Romanek, would you like to come forward, sir? Is there anything else you'd like to state?
Yes, sir. This has been a very challenging process. I went down to go for the variance on it, and like I said, I was trying to make the July variance, but it was already full time. I can tell you that I've had numerous conversations, and I got to be honest, I'm exhausted from this process of trying to build a home on a lot that I own. right? I also understand that there's a concern regarding my plan and my footprint. I do plan on putting between a 2,000 and 2,400 square foot home on the lot. I would like to put a garage on the lot. I've got 4 or 5 classic cars. That is my passion, and that's what, and motorcycles. I don't know where I'm going to put that yet, because my main focus is to put the house on the lot first, and then work with building, DRC, forestry, whatever, to make sure that I save those trees. I don't want to lose those trees. I had a property here in Ormond Beach at 106 Knoll Estates that had numerous trees, and but that was on 1.6 acres. This lot reminds me a lot of that lot, only on a smaller basis to maintain. If this board feels that they're not able to provide me the variance that I'm requesting, I would like to request a continuance if required. I know that a denial will prevent me from doing anything for 1 year, according to code. Don't want to be pushed up against that. If there's not enough information, I believe I provided lots of information, but if there's not enough to satisfy this board, I would like for consideration for continuance and not a denial.
Okay, I just wanted that it be put in the record. You understand that even if we were to approve this variance, you would still have to meet the requirements of this tree ordinance. You'd still have to work with those folks. Okay? So this is the point I'm trying to make. I don't want to have you keep on coming back and forth. Rather than do that, I would like to, me personally, I'd rather make you understand that even though, because I know that some of the concerns are you haven't worked it out with the tree people, but just because we approve the variance, whether we do or not, you would still have to go through those hurdles, or you just have to deal with that. I just want that understood. I don't want it going back and saying, well, they approved the variance, I need to build within this footprint.
There's more than that, sir. I have to maintain that 35% or 30% lot coverage that I have to agree to. Got to pull a building permit. It's got to go through all their processes and review.
Exactly.
I've got to go through the forestry side and have them take a look at the tree drip line on that and negotiate with them of what I want to put in there. I've got to go to health department and have a well put in along with a septic system. So this is not just an idea that I have that I've got everything that I want. I know there's a bunch more things that I've got to go through. My main purpose is just to get the footprint established of where I can work into and negotiate with everybody else about what I want to put in and where I want to put it. Okay. But I understand completely what you're saying.
Okay. Mr. Bender.
Just for information to kind of help you along from my stance. Where I'm struggling is the front yard setback, not understanding why. It appears that you got a 200-foot deep lot, so I'm not feeling that front yard setback. And then from the side, if we had a 100-foot lot, that's gonna, even if you went with 15 feet setbacks on each side, that's still gonna leave you with like 70 feet to establish someplace in there. So I'm thinking that the variance that you're requesting should be coming off of the rear of the lot, and I think we can get home.
Oh, I was just trying to be uniform with my request. 2020, like most lots, I have never seen where they've got a different front variant or a setback than a rear setback. The 40-foot front setback is not a concern of mine. I was just trying to be uniform, the 20 in the rear, but I'm applying for 10 and 10, not 15 and 15.
Right, I see that, but the requirement is 15, and you're asking for 10.
Yes.
And that's another thing. I'm thinking, even if you did not go if you use the current setbacks of 15, that still leaves you with 70 feet to establish within there and not ask for those variances. So you're asking less, and you see if you can fit it in that hole.
The reason why I wanted the 10-foot setback was that eventually I want to put a car garage on my lot. It's going to have to go on one of those sides. If I've got the home kind of in the position of where the barn is right now, that footprint area, part of that footprint area, I'm not going to have a whole lot of room behind me to do that and maintain my setback.
Can I mention something? And that's where variances come into play. If you have a house that meets conforming and you said, oh, now I want to build a garage.
Okay.
I'm sorry, go ahead.
Let Mr. Bender finish
Oh,
his
I'm sorry, I
comment
thought he was done.
first.
I'm
Go
sorry,
ahead.
I'm sorry, Mr. Bender, I thought you were.
Then in your designing of what you're going to come back to us with, maybe try to factor that in. Say, this is where I want to put the home. If I put the home here with this, I need this setback on this side in order to be able to establish my garage. Now we have a reason to see why you're looking for that, where it's going to be. Then maybe you don't have a variance on one side, it's just on the side where the garage is going to be. And that's easier for us to get home with.
I got it. I can tell you too, sir, that once again, I submitted a non-conforming lot letter, that my setbacks are set on a 1 acre lot.
I understand.
And I'm adjusting that to accommodate that I have a ½ acre lot, less than a ½ acre lot. And that's why I'm requesting the setbacks. I have no problem giving you the 40 in the front. I need the 10, 10, and 20, 20 in the rear and 10 on each side, so that I can have buildable area. I got no problem giving you 40 foot in front whatsoever.
Well, that's where I stand.
Yes, sir.
Okay, so you know.
Yes, sir.
So Mike, oh, I'm sorry.
Okay, Mr. Costa first, he wanted to speak.
So I understand your predicament. As a owner builder, I'd like to know what my footprint is before I design the house, because there's X amount of monies that you have to expend up front to come back. Okay, I've designed this house based on setbacks that I don't know that I'm going to get or not get. That's months and dollars that are wasted in engineering and architectural fees. So I understand getting a buildable footprint. Regardless of what happens here today, assuming that you get your setbacks, and I'm with Mr. Bender, I have an issue with the front yard setback. The other three I'm not really concerned about, but the front yard I do. Short of that, assuming that you got what you need, you do realize, and I think you've already acknowledged this, you're not done jumping through hoops yet. We're the easy spreadable butter, and you're about to get the hard chunky stuff. So as long as you're aware of that.
Put some heat on it, it melts.
Okay.
Okay, see, I kind of look at this from a different perspective, and maybe I should leave this for commission comments, but what I look at it as, he's got what he's saying, he's got a non-conforming lot. The Mh6 setback are for a 1 acre lot. He's got a lot that is less than a ½ acre. So basically what he's asking to do is, because of the size of the lot, he's asking for a variance to the side yards and front yard, which, is it reasonable? He's got a smaller lot that would be normally on Mh4. So my question that I have to ask myself, is it reasonable based on the predicament that he's in? So I understand where he's going. And I think he's very aware that he's going to have to deal with the tree ordinance, and he's going to have to deal with other things there to meet his setbacks for his well and his setback for his septic tank and all that. So in taking all that in perspective, and you don't want to hamstring him to where if he comes, that he has to come back. If we deny the variance today and he decides 2 months down the road to put a shed there, he's got to wait a year before he comes back. Does he not? Okay. So the question is he being reasonable? And with what he has to work with, that's where I'm looking at. I mean, yes, it's normally the setbacks are 40, 40, and 15. I get it. But that's on a normal 1 acre lot. He doesn't have a 1 acre lot. He's got less than a ½ acre lot. It's a non-conforming. He's produced a non-conforming letter, and he's just trying to find something that he can work with. And I think, to me, that would be a hardship to try to keep him within those parameters on that small of a lot.
And Mr. Chair, I tend to agree with you wholeheartedly on that. And like I said, I kind of stated my point, but when we get a moment, I'd have another question for staff after we've had a couple comments. Yep.
Okay. As well too, and it brings up that exact point, because I wholeheartedly agree with everything that we're saying here. But staff, you said that there was, in the report in 2018, there was going to be a rezoning of this to try and make it, but that the community did not want that. Is that correct, or what is that?
That is correct. We tried to address the setbacks in this area. However, with what we would have had to change it to, they would no longer be allowed to have farm animals. Right now, they are allowed to have farm animals for personal use, and the community came out and said they didn't want to change the zoning because they wanted to keep their farm animals, and so they decided that they wanted to deal with this as variance issues as on an ongoing basis.
So it was for farm animals, not for density or anything like that?
Well, everyone in this area has problems with setbacks.
Absolutely, yeah, exactly, yeah. But I just wanted to make sure that the community wanted to keep animals. Is that what it was?
Yes, sir.
Okay, that helps. Thank you so much.
And it's a non-conforming lot. That's what I'm focused.
Well, and that's my question actually to staff. This is a non-conforming lot. Is this a predominant issue in that area, or is this a one-of-a-kind issue?
No, it is a large issue in the area.
In the area.
There
So
are many
you have
small
a
lots
good
there.
number of non-conforming under the MH4.
Yes, this is an older area that does or did have a lot of mobile homes.
Mhm.
It's an enclave of Ormond Beach, and now we have people coming in and wanting larger homes.
Prior to it being MH4, what was it? Do you know?
I'll have to get back to you on that. It's been MH4 for quite some time.
I'm just looking, was it an administrative change over to MH4 at some point in time,
No,
or?
we attempted in 2018 to move from MH4 to increase the setbacks to an MH6.
I understand that, but that would eliminate the folks who were already there that had the farm animals. And I understand that point, because if you're on a half an acre and you got farm animals on any other zoning, that would not be allowed. In this particular case, it is, and I get that. So you just said something interesting. You were going to change it to which zoning?
MH6.
And what are the setbacks there?
I don't recall off the top of my head. I
Can we
apologize.
take a pause and find that out?
Sure.
'Cause
I'm pulling it up right now.
I think that would help us here quite a bit.
So for the MH6 zoning classification, it requires a minimum size of 10,000 square feet and a minimum lot width of 85 feet. The minimum yard requirements in the front yard are 25 feet. The rear yard is 25 feet. The side yards are 10 feet. And, well, there's no waterfront in this particular, but it's 25 for waterfront.
And if I'm listening to that, I think that his requests are reasonable all of a sudden.
That's where I'm going.
And I'm glad I went through this line of questioning, because this now changes the entire picture.
Agreed, 100%.
Whenever you're ready to close the floor, I'm ready to make a motion.
Mr. Chair, one of the things is there's a condition number 3 that staff is recommending. It's recommending a conservation easement over the drip line of the historic trees. And has restrictions on what you can do in that drip line.
Should we not let forestry deal with that?
Well, I mean, that's my understanding is that it was a request by forestry. You know, if the commission determined that to preserve those trees and shift the buildable area, but it's ultimately the discretion of the
I
commission
can
of
tell you, I'm
whether or
not
not
in
you want to
favor
do
of putting conservation.
No, the
easement
moment
on
you
it,
put a
it's-
conservation easement on there, you've just restricted his buildable footprint, period. That can be hammered out during permitting, in my opinion.
I got a question for you then. If that restriction is in there and he was to build a house and then the tree restrictions go away, he could tear the trees down or do something, but this would restrict him from doing that. Is that correct?
Yes, the conservation easement would prevail regardless of whether or not he.
Now, I'll buy that.
It becomes a separate provision than the normal execution of the tree permits, which is, Keith, your county forester stated, once you get that CO, those historic trees are able to be removed pursuant to, PLDRC approval. So if you put that separate restriction, that's an entirely separate restriction that operates independently from the tree ordinance.
So he could not then build a smaller house then after that, build a bigger house and tear the trees
Yes,
down.
that's why I wanted to draw it
Yeah.
attention so that this commission
that helps
knows
me.
what
That
it's,
helps me a
what it's
little bit.
ruling
Thank
on
you.
if it decides to put that condition on there.
I'm not comfortable with putting a conservation easement on private property.
Nor am I.
Because why would you put that kind of restriction on an individual's property rights. I think we're just overstepping our boundaries there and continuing to require these regulations on private property. That's where I'm at with that.
Because I'm for conservation, I agree with you on that, Chair.
To me, I mean, that's my opinion. All right, any other questions for the applicant? All right, sir, you can have a seat. Is there anybody, do we have any public participation forms on this? All right, I'm going to close the floor for public participation and open up for commission discussion, and then we'll make a motion. Now, I understand where you're coming from, Jay, but to come here and put conservation easements on private property, residential private property of all things, I think we're overstepping our boundaries on that. And as far as private property rights. And then as far as what I was saying previously, and I'll state it one more time for the record. Here we have a piece of property is non-conforming. We know that it's non-conforming. They've got a viable non-conforming letter. It's less than half the size of what is required in the Mh6. Staff has already made the comment that they tried to rezone this to Mh6 which would have reduced the setbacks regardless, and then they didn't do it because of the agricultural requirements that goes along with it. And I do understand that also, why someone wouldn't want to change their zoning. So I'm looking at, is this reasonable? And when I say reasonable, is he being unreasonable by asking for a footprint therefore? And he's still got to go through, before he can build anything, he still has to go through forestry and get something worked out with them to save the trees. And it seems like that's the big issue. So I think that moving forward, that he's not being unreasonable, and that's just my opinion.
Before there's a motion made, can I ask a question here? If we were to make a motion for approval here, can we revise what he's asking? In other words, he's asking for 20, and can we make a motion to give him 25 as opposed to 20? Can we make that change on the approval?
Yes, you can be more restrictive. You can grant a lesser relief. You just can't grant a greater relief.
Right. I'm looking at to mirror the setbacks you gave me for Mh6, which is a 5-foot differential on the front and back. The sides would be the same as what he's requesting, and that's why that way it's consistent, because if this is predominant within that area, and we know there's an influx of folks moving to the area that are buying land and building because they want that Florida dream, we're going to see this again. And I'd like to be able to say consistently that, hey, we're going to, yes, I remember this area, we're going to stick to the Mh6, and therefore everybody has 25, 25, 10, and 10.
That's up to the commission. They can change those, the front.
I'd like to ask the applicant. Yep,
Yes,
please.
can the applicant come forward, please? Do you understand what's being discussed here, sir? Do you have a problem with the 25 feet?
Only problem I might have an area with is the rear side, due to the fact that I'm putting that house kind of far back. Put a shed back there, I don't want to cause a problem. That's what I have to work with, by all means.
It's a 5-foot differential for a potential yes vote. That's what I'm.
Yes, sir.
Look,
If that's going to hold me up, I'll take the 5 foot, all right? I'll give it up.
Mr. Chair, I hate to bring up the trees again, but if you had a Mh6 zone property and someone wanted to avoid impacting the trees, that would be kind of a justification to grant further relief on the rear side, move that house away from the trees, which I think are closer to the front of the property.
Would they not come back though with the permit during the permit process for an additional variance?
Well, at that point in time, we would recommend the conservation easement, because they're justifying that we want to preserve the trees and we want to hold the applicant to their word that they're preserving the trees by putting a conservation easement on there. So the unfortunate part about this is when this started, we had no information about where things were going.
Right. We're just giving him a buildable footprint at this point, so we may see him again.
Potentially.
Well, he can't come back for another variance to the rear for 1 year. This is the point I was trying to make.
Is that
if he's good with the front? I mean, I don't know how the rest of the board feels, but if he needs the additional 5 foot in the rear, what is, we're looking at 20. We're not 5 foot.
Chair, can I ask one question?
Stay away from the trees. It helps in the tree conservation.
I totally agree, but my only question would be more of an ministerial. If we approve this, does he have to wait a year if he wants a variance on the rear again, if it's approved? Oh, they're checking right now, so, because I know it's if it's denied, he has to wait a year.
Yes,
but
but
if
yes, if you're approved and you come back,
approved,
and in
then
the,
he
during
says
the,
during the building process, I need extra
There you
5
go.
feet, can he come back a month later? and
during the
ask?
permit process, that's part of the negotiation with forestry.
what
So
I would
listen,
like
I
to
need,
know.
if I get 5 more feet, I can replace, and that's when he comes back in a
The
second.
year provision applies, so the commission or county council shall not otherwise rehear a petition based upon substantially the same facts or issues until at least 1 year has elapsed from the date of rendition. So it applies to both approvals and denials. Unless at the time it denies an application, it shall do so without prejudice, and in that event, the applicant may apply at any time thereafter. So
Approval or denial, he would have to wait a year on if we change the rear.
yes, I believe that's the function. Let me check another.
While he's
While you're
doing that,
checking that, I was going to say that I kind of feel the same way on both of these two, Mr. Costa, Mr. Mills. The 5 feet
He
with,
might
to
need-
protect the
he might need that
trees.
in order to
In
meet
this
his
particular one, with the
purple
information we have, I
conservation.
could,
Of the trees.
Mr. Chair,
Yes.
while we're going through that, I'm okay with various, variants, 2, 3, 4. But I'm still struggling with, 1. I would ask that, when we do the motion on this, that we separate each variance and do them on their own. Because I'm not in support of variance 1. Other 3 I can live.
Even if we went to the 25 feet?
Yep.
Okay. Okay, because variance 1 is the 20 would be, my understanding is what we're looking at, the applicant has agreed to is going from 20 to 25 rather than, okay. Yeah, we can handle them one each individually. All right. Any other discussion?
I'd like to ask the property owner if you had the rear and the 2 side setbacks for what's been discussed here, you can live with that and without a variance on the front?
I could, but I also heard a comment that they were trying to uniform that area to Mh6, which reduces that front 25 feet. and
Well,
the rear to
I understand that, but that's not gonna help me get there with a yes vote.
I understand, sir. Yeah, I'm okay with the 40-foot in front. That's what you require, yes.
Mr. Bender, I have a question. Would you be applicable? We're talking about that extra 5 foot in the back. Would you be applicable to doing the 40-foot front setback and doing a 20 back setback, since that's where you want to build? That alleviates the need for 2 of them, gives you the further back, and then the sides at the
10, 20.
10, 10, 20, and 40 in the front. Is that something that could get you there, Mr. Bender?
I'm good.
I appreciate that. If there's no other discussion, I'd be prepared to make that motion then.
Go ahead, shoot for it. We're gonna handle all of them at the same time then?
Can we do them at the same? Yeah.
Well, do variance 1 through
I'll do-
3, and then we'll address the variance 4 because that's gonna be a different motion,
Okay,
obviously.
sounds good, sounds good.
I mean, variance 1.
Yeah, we'll do variance 1 and then we'll do 2. Is there any other things from staff? Are we good?
No, if the discussion is to leave variance 1 at 40, then our recommendation would just be to deny variance 1.
Okay. So then I'll make a motion separately. In case V22-115, variance to minimum yard requirements on rural mobile home zone property. For variance 1, we deny variance 1.
That would leave the applicant with a 40-foot front setback. Correct?
Doing them separate.
Well, let's do 2 through 4 first.
Okay. Okay, sorry. So then
we're not guaranteeing that 2 through 4 is
Sounds
gonna
good.
go through. Let's
Sounds
do 2
good.
through 4
So then let's do
first.
2 through 4. So for variances, I recommend approval variance 2 with the reduction from 40 feet to 20 feet. Variance 3, the reduction from 15 feet to 10 feet, and variance 4, the reduction from 15 feet to 10 feet. And the staff recommendations, we're going with staff recommendations 1 and 2, not 3, correct?
That's what I
That's
felt.
the motion.
I would second that.
Okay.
Okay. I've got a motion to approve variances 2, 3, and 4 as stated in the request. with the two staff recommended conditions, 1 and 2, and striking recommendation 3 from Mr. Feller and a second from Mr. Costa. Any discussion on the motion? All those in favor signify by saying aye.
Aye.
Any opposed?
Aye.
Motion carries 6-1 with Mr. Young in dissent.
And-
Okay, now let's handle variance 1.
Alrighty, I'll make the same motion. In case V 22-115, for variance 1, I vote that we deny that variance.
Okay, I got a motion to deny variance 1 from Mr. Feller and a second from Mr. Bender. Any discussion on the motion?
So a yes vote is a denial, and no vote is an acceptance of what we have, correct?
A no vote fails the motion, so you can make another motion for an alternate setback, whether that's 25 or 20 feet.
I'd like a discussion on the motion.
I'm with you.
Go ahead, Mr.
Again, going back to the Mh6, keeping everything uniform, 25, 25, 10, and 10. We're going to see this, it's kind of like the boat dock thing. We're going to see this, and it's going to come in waves. And I'd like to be able to keep consistency. And I think 40 on basically a half inch or half acre, less than a half acre wide lot is a bit excessive. And looking at some of the aerials that I pulled up on my phone real quick, there seems like a lot of folks are well inside that 40-foot mark currently. So I don't want to penalize him on this particular case, and I want to give him ample footprint to dance around those trees and actually make it work.
I agree with Mr. Costa.
Okay, so I've got a motion to deny variance 1 from Mr. Feller and a second from Mr. Bender.
Before we take a vote, I'm gonna tell you just what I think and what I feel.
Okay.
If I had known it was going to do that, I would have said, no, we're going to have to do number 1 first, because I made it clear as to what my position was, and I never would have voted yes on 2, 3, and 4 had I thought it was going to do a flip like it's doing right now, just so that you know.
Okay, Mr. Bender, I don't think that was done intentionally, but I just didn't want to throw that in there on variance 1 and then something left that. I mean, it wasn't, I don't think that was the intention, other than just getting to where we needed to be. In stating that, the vote would have been 5-2, and it would have still carried through as okay? I didn't mean to offend you or make you think something was being done out of, trying to get somewhere. Okay.
So where are we at?
We're on variance 1. We're at denial. I got a denial motion for Mr. Feller and a second for Mr. Bender.
So voting yes will be going with a denial.
That's correct. Voting no will mean that we can either entertain another motion or it dies. Okay. Any other discussion on the motion? All those in favor signify.
I have a question. This last discussion just got. Okay, if you're voting no, the motion is to deny variance 1.
That's correct.
So if you're denying it, aren't you voting yes?
No.
Not necessarily.
No. Okay, that's
You're-
where I'm
you're-
confused.
You're voting on the question that's being presented.
Which
So the
is to
question is
deny
to
it.
deny.
Right.
So if that motion fails, then the question fails. So any member can make another motion, because you haven't resolved the issue yet.
I understand that, but my question is, it's a motion to deny.
Yes.
That would be a yes vote.
It would be a yes.
Agree with that motion to
Yeah.
deny.
Yeah, to
Okay,
deny.
thank you. Thank
A
you.
no vote would not agree with
Would
it.
mean that you're not agreeing to deny it. Okay.
Right,
Thank you.
gotcha.
Okay, any other discussion on the motion? Okay, all those in favor signify by saying aye.
Aye.
Any opposed? Aye.
Aye. You might want to do a roll count.
Yeah.
Let's do a roll call. Mr. Feller.
Aye.
Mr. Young.
Aye.
Ms. Shelley.
No.
Mr. Bender. Mr. Costa,
No.
Mr. Sixman,
No.
and I'm a no. So the motion does not carry. Now, I will entertain another motion for variance one.
I'd like to make a motion, Mr. Chair, on case number V-22-115, variance number 1, reducing the front yard setback from 40 to 25 feet with staff recommended conditions number 1 and 2 only.
Second.
Okay, I've got a motion to move variance one from different from the request from 20 to 25 with the staff recommendations of 1 and 2, striking recommendation 3 from Mr. Costa and a second from Mr. Sixman. Any discussion on the motion?
I'd like to say, the only thing I'd like to say on that is I totally agree. I mean, going to the Mh6, I'm all for it, but I think this was a perfect example of like trying to come to all kinds of things, and now we're just kind of going back to just a standard when we could have done a standard and then left it at that. So, I mean, I would have been okay with the standard 25, 25, 10, 10, but we kind of came to this agreement with the homeowner, and now we're changing it a little bit. So I do agree with that. How I vote is reflective of that.
Okay. Any other discussion on the motion? All those in favor signify by saying aye.
Aye.
Any opposed?
No.
Motion carries 5-2 with Commissioner Young and Bender in dissent.
Feller.
4-3.
Feller.
You're in dissent too? Okay, so it's 4-3.
Right.
Got it. Okay. Hopefully that'll get him where he needs to go. All right, Ms. Shelley, could I get the next case record, please?
Yes, sir. Case number V-22-116, variance to the minimum floor area requirements on mobile home park Mh6 zoned property.
Okay, thank you, Ms. Shelley. Mr. Hanson.
Good morning once again. This particular variance is a hopefully a fairly simple one. What's going on is there's a legally non-conforming mobile home park that's 1.37 acres. It was granted a rezoning back in '85 to turn it from the general commercial B4 zoning to the Mh6 zoning classification. Based on the density requirements for that zoning classification, it's allowed to have up to 10 units on the actual mobile home park. Now, this is resultant due to kind of a mystery, unpermitted mobile home appearing on the mobile home park. There was an application for building permit that was ultimately withdrawn, but then it ended up being put in place anyways. The current applicant is a new owner of the property, kind of an interesting situation where the applicant bought controlling interest of the company that owns the mobile home park via contract for deed. So once they're able to resolve this situation and finish the purchase agreement, then the former owner will come off the contract for deed, or as far as the ownership. But the variance is for a reduction in the minimum floor area for a mobile home to be sited in the park. So Mh6 zoning classification requires a minimum floor area of 480 square feet. And what we're looking at is a mobile home that was placed in the park that measures at 455 square feet. So the mobile home on the park is 25 square feet less than required. Staff made a recommendation for approval for the variance as it met all 5 criteria for granting said variance. In the sake of brevity, I will be open to any questions the commission may have.
Any question for staff? Hearing none, is the applicant present? Can I get you come forward, sir? Can I get your name and address for the record?
Mh6 3399 Buttonwood Avenue, Deltona, Florida.
Okay, you've heard the staff report. Anything you'd like to add to it?
No, sir, just that the mobile home was put there before I actually purchased it, so I'm kind of inheriting a nightmare that I'm trying to get to the bottom of. because there's
Okay.
also other zoning or permit issues that I'm also going through as well. So I'm trying to do the right thing.
All right, sir. Do we have any public participation forms for this case? Anyone in the audience like to speak to this case? All right, sir, you can have.
Mr. Chair?
Yes.
Oh. I apologize. Excuse me, please. The next one.
Okay, Mr. Young, go ahead.
I got one question. That, you're talking about a mobile home that somebody is renting the lot from. It's not, is that,
It's a park-owned home, so I do own the home.
oh, it is a park-owned home?
All of the mobiles on the lots are park-owned.
Okay, are park-owned.
Park-owned.
That's what I wanted to clarify.
Yeah,
Okay.
park-owned. So it's
You're
vacant right now.
intending on keeping that one in there?
Yes, correct, yes. Yes, I would like to get a CO and get a tenant in there ASAP.
Ms. Smith, you had a comment? Okay. Mr. Bender?
Just out of curiosity, when I drove by this property, I noticed that there was an RV sitting there. Is that something that's being rented, or is it just?
Negative, that's being sold.
That's being sold?
It's not allowed to be on that property because it's a zone for mobile home and it's not zoned for RV.
Right.
So yes, that is currently for sale.
Just out of knowing that area,
Yes, sir.
I was quite surprised how well that park
Thank you,
was
sir.
kept compared to.
Yes. There's
others
a
that
neighboring
I've seen.
county property that's a dilapidated gas station, but
Yeah, I'm
that's another.
very familiar with that property.
That'll be another day.
But no, you kept.
Thank you, sir. I appreciate that
Kept up very well.
compliment. Thank you.
Okay, we're going to close the floor for public participation, open for commission discussion or a motion.
I'm ready for a motion.
Go ahead, Mr.
Okay.
Six.
I'll go with staff recommendation of approval of case V 22-160
All right.
with the
And
two conditions.
with the two conditions. Are you good with that, Mr. Bender? Okay. Okay, I got a motion to approve variance 22-116 with its two staff recommended conditions from Mr. Sixma and a second from Mr. Bender. Any discussion on the motion? All those in favor signify by saying aye.
Aye.
Any opposed? Motion carries unanimously. Ms. Shelley, could I get the next case read in the record, please?
Case number V-22-119, a variance to maximum fence height on urban single-family residential R9 zoned property.
Thank you, Ms. Shelley. Mr. Shamp, could I get the staff report on this one?
Sure. Good morning again. This is, excuse me, this is a variance for maximum fence height in a front yard. This property in particular is unique in that it abuts two roads, essentially. So you have two front yards, and technically the yard in question is at the rear of the home, but because of the way the ordinance is, we have to judge it as a front yard, so we restricted it to 4 feet. There is not a special condition to justify the change from 6 feet to 4 feet. This is just a typical yard. There's no precedent for it in the neighborhood. Based on the written petition of the applicant, they describe a need for privacy. A 4-foot fence would provide privacy and a barrier to observe trespassers. Staff recommends denial as the variance does not demonstrate special need or justification for a taller fence height. If the PLDRC was open to a different decision, that would be fine as well for approval. We did receive 2 letters of opposition from adjacent property owner. Those are in front of you, and I'm available for comment.
Okay, any questions for staff? Okay, hearing none, is the applicant present? Good morning, sir. If I could get your name and address for the record?
My name is Lucas Pizzo, the owner at 3878 Cardinal
Okay, can you
Boulevard.
pull those up a little bit there? The mics in
sorry.
front of you? There we go. Okay.
3878 Cardinal Boulevard in Port Orange.
All right, sir. You've heard the staff report. Is there anything you'd like to add to that or make any comment on?
Not surprising, I do disagree that I don't meet 4 out of the 5 criteria. Throughout several sections within the report findings, it says that a 4-foot fence accomplishes the same as a 6-foot fence. regards to security and privacy.
Can we turn his mic up or something?
Is that better?
That's better, yeah.
Okay. I do disagree that a 4-foot fence accomplishes the same as a 6-foot fence. If that was the case, a 6-foot fence would not be the standard for most homes for pool requirements, security. In regards to privacy, I mean, as you can see, I'm over 6 feet tall. A 4-foot fence would not prevent me from looking into a yard. Excuse me. My property is unique, as it's stated in the report. My backyard actually adjacents the road behind me. I do intend to use it as a backyard. It is not a front yard. It faces the rear of my house. A 4-foot fence could easily be scaled by anyone trying to enter my property. I submitted photos in the report. I don't see them. My security cameras have actually caught people peering into the windows of my home at night, which is alarming, considering I do have a young daughter that, you know, I think anyone would be scared if someone was looking into their home in the middle of the night. Other than that, I have nothing much to say.
Okay. Mr. Bender?
I guess my first question is, do you live there, or is this property being used as Airbnb?
I do not live there, actually. I do live in California, so I have had made the journey out here for this meeting specifically. I will be honest, when I first purchased the home, it was used as a short-term rental. When I purchased the home, I had contacted the county and asked what the restrictions were. They said there were no restrictions in regards to that. After those findings, I have ceased operations. It is considered a second home now. I'm making improvements in regards to that because I intend to use it as my personal property, which has been the case in the meantime as well.
There was something that, if I'm not mistaken, I read in the staff report that there was neighboring property right next door that had the same type of fence. And is that the case?
Yeah, there was a home across the street from Mr. Vixo's home. If you see in this image, I believe it's that home right there. You can see the fence in the corner. It's an unpermitted fence. And they're going through a code violation issue. So there is no precedent in this neighborhood for the fence he's requesting.
Thank you.
Would that other one be considered a front yard?
Yeah. Yeah, that's what, I'm sorry. I didn't mean to interrupt you. I just rereading this again. It says right here, by 2 front yards. So we're dealing with a 2 front yard property here.
Correct.
Which I don't know during the original presentation if that actually came out from you, or I'm just now catching it.
He did.
Did he? Okay. So that changes perspective on everything.
And Chair, can I?
Yeah. Yes, sir.
I drove by this property because I'm under the same things. Because the one thing, and again, whether it's rented or whether it's not rented or whatever, it's your property, and 6-foot fences are usually because of line of sight. And Venetian Way is the backyard, and it doesn't curve towards where there would be any line of sight issue for any traffic. So in looking at it, I think it was set back from the front, which is cardinal, in an appropriate manner. So yeah, I don't think Venetian Way has any sight impairments because of going to a 6-foot fence on this. That's from me driving it.
Okay. Any other questions for the applicant?
You said this is a second home, correct?
Yes, sir.
Your plans on moving here or just vacationing here?
No, moving here once I retire.
At some point. Okay, thank you.
Mr. Bender?
When you introduced yourself, you gave a New Smyrna Beach or Port Orange address?
Port Orange, sir.
But you live in California, so which is it?
The request is for this property, sir.
I understand that, but when you, for the record, you said that your address was report on, but then in your comments, you said you live in California, trying to figure out
Would you like my,
which it is.
would you like me to provide my California address as well, sir? I'm not sure I understand the question.
Well, I'm just trying to make sure that we're on the same page. So you live in New Smyrna, Port Orange.
It's the second home for me, yes.
You are the owner of that house.
Yes, sir.
Okay. Any other questions for the applicant? All right, sir, we do have 2 letters of opposition on this that was put into the record. Would you like to comment on either one? Have you seen any of these letters?
I have not, sir.
Okay. Well, I'm gonna give them an opportunity to look at them because they are in the record here, sir. You just take a quick look at those if you would.
Mr. Chair, can the staff maybe put them up so the public can see them since we're considering them? They're part
Yeah,
of
we
this
can put
discussion.
it on. Yeah.
You
Can
have-
you put them up on the overhead? Is there any, let me see if we have it. Do we have any public participation forms for this? Okay. Does anyone in the audience like to speak to this case? All right. There's that. If you can just take a quick look. Sure, go ahead.
I'd like to, Trish, I just have a question for y'all real quick. It's not important, but for clarification. On this item, I noticed, I don't notice any staff conditions if we decide to go forward with this. Is that correct?
Let me check.
Usually when it's a recommendation.
That is correct. We did not provide any conditions.
Okay.
However, you are welcome to add conditions.
Great, I understand that. I just wanted to verify that. Thank you. Thought there would be conditions.
And Chair,
All right, you had a chance to look at the letters. So would you like to respond to those letters?
I guess the only a certain section within the letter that a 6-foot fence would be gaudy. I don't feel that way. Most of my neighbors do have 6-foot fences already. In fact, the neighbor just south of me, or if you're looking at my property to the left, they do have a 6-foot fence that's wooden. And it's actually fallen over. It's dilapidated. My section of the fence would actually replace that and increase the aesthetics within the neighborhood of the community. My neighbor directly across the street on Cardinal, to the right and to the left of them, they both have 6-foot fences. Most of the neighbors within the area do have a 6-foot fence, so I'm a little confused as to how a 6-foot fence would be gaudy.
Okay. And the other question I have for you, if we have a variance site plan, we don't have a condition in here. If we were to limit the variance to what is indicted on the site plan, would you have any problem with that?
I'm not sure I understand what you're referencing to.
Well, what I'm saying is we're doing a variance to the front yard setback.
No.
And I don't want to end up having the fence extend out across Cardinal either.
Oh.
So as you put in the site plan.
We're not doing a variance to the front yard setback. We're doing a variance to the 4-foot fence to a 6-foot fence, correct? Is that correct?
Yeah, I'm sorry, yes.
Yeah, I'm sorry.
Yeah.
I think the concern from the chair is to make sure if you do grant that variance, it would only be on the Venetian Way side.
Yes.
And not to the Cardinal Boulevard, because
Yeah, that's my point. Yeah.
The site plan shows, so the 6-foot is allowed on the other 2 sides of the property, is that correct?
On the side
Yes.
yards, yes,
Okay,
but
yeah, so
because he's got 2 fronts, so
Exactly.
Venetian and Cardinal is limited to 4 feet.
So what we're saying is it would be limited to this plan that was drawn, which is the 6-foot fence connecting those 2. Okay.
Yes.
Yeah.
To the site plan that's submitted for the record.
To the
To the
site
site plan
Yeah,
approved.
exactly.
Yep. Okay.
Can I make a, well, when you close the floor, when you.
Okay. All right, any other questions for the applicant? All right, sir, you can have a seat.
Thank you.
And we're going to close the floor for public participation and open up for commission discussion or a motion.
I have discussion, potentially a motion, but there's discussion, and I know that came back with whether he rents or owns the property. I think that's a moot point. His property owner, he's enjoyed certain rights. This board has passed 6-foot fences on a number of different things. There's no line of sight issue here. When I look at this, he can do a 6-foot on the, I assume it's north and south side, and it would just be, it's administratively because of the 2 front yards. Otherwise, this would be done. Whether he rents the property or whether he lives full-time.
Any other comment? Mr. Costa, go ahead.
I agree with Mr. Feller. If he does or does not have an Airbnb running out of that operation, it has nothing to do with the fence height.
No.
And that's a whole separate, that's a code enforcement issue. That really has no bearing on us at this point. Out of those letters, what I did take was the gaudiness of the fence, and they were talking about a wooden fence, in which case what he's putting in is a vinyl fence. So that kind of took those 2 comments off the table for me. So whenever you're ready to make a motion, I'm ready.
I'll agree.
One thing, well, go ahead, Jay.
Oh, I'll make a motion that we approve the 22-119 with no conditions.
No,
Second.
I would condition it with these as site plan.
Oh, that's right. We're going to condition it with the site plan is submitted.
I would second
Okay. I'll still say second.
Okay. I've got a motion to approve variance V-22119 with the addition of a condition that the fence remain the height to whatever the site plan into what was submitted to the record. Yeah, into the record, and second from Mr. Sixma. Any discussion on the motion? All those in favor signify by saying aye.
Aye.
Any opposed? No. Motion carries 6-1 with Mr. Bender in dissent. All right. Ms. Shelley.
Yes, sir. Case number V-22-120, variances to separate non-conforming lots on prime agriculture, A1 zoned property, and reduce minimum yard requirements.
Thank you, Ms. Shelley, and this is Mr. Shams also.
Good morning again. This variance is to separate non-conforming lots. The 2 properties, I'm going to refer to them as 0070 and 0080, are both owned by the Kohlers. Their intention is to, thank you. So 0070 is the yellow outline on the map to the right, and 0080 is the subject property outlined in red. Their intention is to sell the 70 property and build a home on the 80 property. The subject property is non-conforming due to size because it is split zoned between prime agriculture and resource corridor. It doesn't meet the lot area requirements of either zoning classification. But the parcel was originally conforming before it was split zone with RC. And the subject lot is also a corner lot on Tifford Lane, so it's subject to dual frontages. Variance 2 is for the east front yard requirements. There's a public utility easement along the east side for Tifford Lane, and that encroaches 60 feet into their property. The current site plan places the home 55 feet from this easement, so west of the easement, and it does not meet the requirements of the 100-foot front yard setback. If not for the easement, the applicants would easily meet this requirement. So staff recommended approval as all the criteria for the variance are satisfied. And I'm available for questions if needed.
Any questions for staff? Hearing none, is the applicant present? Good morning. If I could get your name and address for the record, please.
Tina Kohler. I reside at 1035 property. Different.
And you, sir?
Brad Talley, the one that will be residing at 1045.
Okay. And that's your current address, sir?
No, 915 Summit Ash Court, DeLand, Florida.
All right. You've heard the staff report. Anything you'd like to add to that? Comment on?
So right now, there was a home on that property that we demolished,
Okay,
and that was sitting next to power lines even closer.
uh-huh,
This is on the opposite side, that it's one pole that's sitting in the middle of our property.
okay,
And it's been there, and there's been, Tifford Lane the whole road is an easement. So from start to finish is an easement. It just so happens to run 3 of my parcels. Selling the property, and that wasn't, I don't know why that was put in there, but I took down the home, putting up a home, my daughter and my grandchild.
okay.
My son. Sorry. You can live there too.
I can live there too.
Okay.
Is that in the motion? You want us to add your name?
I'm sorry.
Yeah. All right. Do we have any questions for the applicant? Okay. Let's see if we have any public comment or anything. If we don't, we'll close the floor and have a discussion up here. We may have more questions for you. Sit close by. Okay? Do we have any public participation? Anybody would like to speak to this case? We're going to close the floor for public participation. That will have for commission discussion or motion.
I'll be glad to make a motion
Go ahead, Ms. Shelley.
that we approve variance requests 1 and 2, case number V-22-120, as the variance successfully meet all 5 criteria for granting variance.
Okay.
Second.
I've got a motion to approve variance V-22-120. There is no conditions on this, is there?
No
Ms.
conditions.
Smith? Okay. For Ms. Shelley and a second for Mr. Sixma. Any discussion on the motion? All those in favor signify by saying aye.
Aye.
Any opposed? Motion carries unanimously. Ms. Shelley, could I get the next case, please?
Yes, sir. Case number V-22-122, variance to separate non-conforming lots on rural agricultural estate RA zoned property.
Thank you, Ms. Shelley. And this is Mr. Shams again.
Good morning. This is a variance to separate non-conforming lots on rural agricultural estate zone property. The applicant wants to build an accessory structure, but the parcel does not meet lot area requirements. The parcel was held in common ownership. The subject parcel is outlined in red, and the 2 adjacent properties were held in common ownership. He simply needs a separation to apply for building permits. Staff recommends approval as all criteria are satisfied. And I'm available for question.
Thank you, Mr. Shams. Any questions for staff? Is the applicant present? Is Mr. Griswold here? Okay, we're going to proceed without him then. Okay, do we have any public participation forms for this case? All right. Anyone like to speak to this case? Okay. We're going to close the floor for public participation, open up for commission discussion. If anybody has any questions to staff or anything, we'll...
One question.
Go ahead, Mr. Feller.
Sure. One question, and this is probably just since we're on brevity, since he's not here. These were all held in common ownership. Will this separate the common ownership of the 2 yellow parcels now too, or would that, so?
Not right now, but I think a few items later, you're going to have ordinance 22-134, which will solve that issue.
Okay, thank you.
I'll be glad to make a motion.
Okay, Ms. Shelley, go ahead.
To approve variance case number V-22-122, it meets all 5 criteria for granting the variance.
I'll second.
Okay, we have no conditions on this one
No
either,
conditions,
right?
sir.
Okay, we've got a motion to approve V-22-122 from Ms. Shelley and a second from Mr. Young. Any discussion on the motion? All those in favor signify by saying aye.
Aye.
Any opposed? Motion carries unanimously. Ms. Shelley, could I get the next case, please?
Yes, sir. V-22-123, variances to minimum side yard requirements on transitional agricultural A3 and resource corridor RC zoned property.
Thank you, Ms. Shelley. Mr. Shams?
Hi, good morning. The applicant is seeking 2 variances to the minimum side yard requirements on their property. Variance 1 is to reduce the side yard from 25 feet to 11 feet for a detached garage. And variance 2 is to reduce the side yard required from 25 feet to 11 feet for an RV and boat structure. Based on the proposed site plan written petition, the desired location for both structures is in the side yard in front of the principal structure. Locations were chosen based on existence of historic live oak trees on the east side of the property. The applicant is seeking to preserve the trees. The applicant also stated the structures could not be placed outside the side yard due to the location of a utility pole that would block driveway access. We received a letter from New Smyrna Beach Utilities, and they did corroborate this statement that the utility pole in front of the property would be very difficult to move. Locating them outside the side yard would also obscure the front face of the home, which would diminish front yard visibility and value of the home. In spite of this, staff recommended denial based on the following. The RC area and wetlands on property is not a special condition as it affects all 7 properties on the street. There are other buildable areas in the property where the structures could be located, and literal interpretation of the zoning ordinance would not prohibit the construction of the accessory structures themselves, as the size and orientation could be adjusted to meet the side yard requirement. We did say PLDRC could approve with additional evidence. If they do approve, staff recommends 3 conditions. Condition 1 is variance 1 is limited to the size, location, and orientation on the site plan. Condition 2 is variance 2 is limited to the size, location, and orientation on the site plan. And condition 3 is that the property requires a lot combination to create 1 building site from 1 whole lot and 2 lot portions. The applicant would need to complete this upon variance approval with our land development department. I'm available for comment or question.
Thank you, Mr. Shams. Mr. Feller, you had a question? Yes. No, this is on a different, I think the applicant give us this to refer back to. This was something that the applicant provided us this morning. Yes, he provided that. He's just in reference to, no. Any other questions for staff? Okay. The applicant, if I can get your name and address for the record, sir.
Good morning, Mr. Chair and members of the commission and staff. My name is Mark Rakowski. I'm a land planning consultant. Been in the business about 36 years now in the area. I'm representing Lisa and Kenny Kane. Kenny is with me here today, and we're talking about 2775 Letha Street. I'm going to say a few words here. I'll try and make it brief, and then Mr. Kane would like to get up and do a few things.
Okay.
We had a PowerPoint. I'm not sure if the staff could pull that up. It's just got a few slides, so we won't bore you too much. Some of this you've already seen before, so if you could just go to the next. There you go. And you have this in your package, but I just want to refer to this. So the request is for the Canes to build 2 accessory structures closer to the side than 25 foot, than the 25-foot side yard allows. One is a structure, a 2-car garage structure. It's about 750 square feet, and the other is a RV and boat storage building. It's about 2,400 square feet. We had a meeting, a nice meeting with the staff, a pre-application meeting that everybody's required to go to. And so we're a little bit surprised on the recommendation, but let me go ahead and explain this a little bit. In the first piece of paper that Mr. Feller referred to is, it was only in February that the neighbor 2 doors down asked for almost an exact same variance and was granted for it with a recommendation of approval from the staff. And I know that, you know, each one of these has to stand on its own. As a planner, I'm very aware of that. But it was just so similar that we were somewhat surprised about that. And it was a different staff member, I think, that wrote that report. However, they did get the variances granted. There's also one correction I want to point out to the board. The staff report indicates that the property is 180 feet wide, when in fact the property is really only 150 feet real wide. I want to make sure that the board understands that. We wish it was 180 feet wide, but we're only 150 feet wide. And I understand, as looking at the survey, you know, I've been looking at surveys for many years of my life. Sometimes it can be a little confusing. But I wanted to make sure you had this understanding. So let me go through the 5 criteria fairly quickly here, so as I don't bore you, and then Mr. Kane will get up. Anyways, the staff report reads that there's no special circumstances. And again, we are somewhat surprised about that, because as that first piece of paper that I handed you says that, you know, the previous one for our neighbors, which was just done in February, says there is a special circumstance. The property was administratively rezoned in 1992. You know, in hindsight, we kind of wonder why it was rezoned. I do understand administrative rezonings as being a planner for over 30 years. I too was involved in administrative rezonings in the 80s and the 1990s as a result of the Growth Management Act of 1985. And it's hard to get these things correct. As one of the previous cases you just talked about, it would have been perfect to rezone the other one to a lesser rezoning, but you couldn't allow horses. So it's not an exact science. It's very difficult to rezone property once it's developed. So the result of this 1992 rezoning was, with the exception of one very large lot, all the other lots have some nonconformities. And if you look on page 13 of the staff report, I have a little table there that shows that except for the last lot that's 3.8 acres, every one of these properties has some type of non-conformity due to the rezoning in 1992. And a general principle of planning is that you don't apply a zoning designation that makes nonconformities. But it was done, and again, I understand it was done. And I think that's an important point. It really creates a hardship for everybody in this neighborhood. If not granted the variance from the 25-foot setback, except for the large lot that's 3.8 acres, this is going to be the only lot that would have a 25-foot side yard setback. And what it would do is it really would kind of disrupt the neighborhood. It would require us to put the accessory structures in the front of the building, which is not ideal. Also, it would require us to remove many trees, which we don't want to do. We like to save the trees. The purpose of buying this property was because of all the nice big trees we had on the lot. The staff did bring up the power pole location, and this slide shows the 2 power poles, one's replacing the other one. If we were to require to have the 25-foot setback, there would be no way to access the accessory structure, because that's right where we want to have the driveway. It's a big boat and a big RV, and in order to leave, you have to go and turn left out to get, because the road dead ends to the right, to get out of the property, and it's just not possible to do. So therefore, we asked the Utilities Commission, can we relocate those poles? And they basically said, heck no, we can't do that. And there is a letter from the Utilities Commission that I handed out to you. I think that's the second piece of paper. And then there's also a slide on the slideshow. This is also an atypical lot. Okay, atypical lot meaning there's water in the back. That means, and the staff on page 8 of 30 of your staff report showed an edited site plan that we've got areas to put accessory buildings to the back. Really, if I'm not mistaken, the staff told us that you can't put anything to the back of the building because it's an atypical lot, it's on the water, and you really wouldn't want to put anything back there because it would obstruct your water views. There's environmental zoning on this, the RC zoning. It really consumes a lot of the property. And with the buffer involved there, adjacent to it, you really can't, it really limits the lot and where you can put things. And then there's a lot of trees on the property. When they purchased the property, they knew there was Australian pines on it. It's an invasive species, and we encouraged those kind of trees to be removed. And so they removed a lot of them that were where we wanted. That's why the decision was made to put the accessory buildings on the side of the house as you're looking at the house to the left, because there were so many invasive species there. There's also more in the back that we have to take care of, but we haven't gotten to that yet because it's kind of a little island, a little difficult to get to. If we had to abide by the 25-foot setback, we'd have to take out a lot more trees that aren't invasive. They're nicer trees, and it's got a nice canopy to it. This is not an action due to the owners. The owners didn't ask for it to be rezoned in 1992. They didn't ask for the power poles to be there. We did try to remove it. The owner wants to keep the nice trees in the front, so this is not an action that's caused by the owner. The second criteria is a little interpretation that would deprive the applicant of rights. Really, again, if we were to have the 25-foot setback with the exception of the one house on the 3.8 acres, we would have the only house in the neighborhood that has 25-foot setback. When I went throughout the neighborhood, I tried to take some pictures, and actually if you look on page 17 of 30, I've got some pictures of the neighborhood where all the setbacks, or some of them are less than 10 feet, but almost none of them are 25 feet. And in the next few slides, if you could turn those on, there's some more examples. There's nothing essentially except for that one lot that has the 25-foot setback. The third criteria is minimum variance required for reasonable use, and we think it is because we're trying to keep those buildings away from the trees. We're trying to have them so that we don't block the house. There is going to be, you'll be able to see the house from the road, although there's going to be some nice tree coverage. So we don't really want to nobody really wants to have accessory structures to the front of the house. We can't put them in the back, and we really can't. I mean, we could put them in the setback, but we'd have to take out a bunch of trees. And again, we think that would be very disruptive to the neighborhood. Criteria 4 is how the request is consistent with promoting the public interest. We really, in a neighborhood, you have zoning in order to make all the neighborhood somewhat conforming to each other. That's the purpose of zoning regulations. In this case, the zoning regulations would require us to have a different house and not conform to the neighborhood. We don't want to have the accessory structures in the front of the house. That would be very disruptive to the neighborhood. We want this house to fit in with the neighborhood. Most of the houses were built 20, 30, 40 years ago, so we're trying as much as possible to fit in with the neighborhood. If we were required again to have the 25-foot setback, we'd really look like a non-conformity in the neighborhood. And really, I don't know why it was rezoned again. Again, we shouldn't have rezoned the property because it just created so many non-conformities. And then the last criteria, staff and I agreed with, that it wouldn't be injurious to the neighborhood. It would really help the neighborhood and make the house fit in. So in summary, we just think that the rezoning in 1992 really created the hardship. There's a power pole really in the worst location that it could be. We tried to move it, we couldn't get it moved. We've got an atypical lot, and we got environmental zoning really limits the location of accessory structures, and we want to really save a bunch of the trees on the property. So the owners would essentially be punished if they had to meet the 25-foot setback when nobody else fairly in the neighborhood does. And there was a variance granted, and I understand every one of these cases must stand on its own, but just down the road, almost the exact same variance was granted. We don't want to remove the trees. We don't want to put the accessory structures in front of the house, and we don't want to disrupt the neighborhood. Again, we want to save trees. We got the power pole in the way. It's consistent with the ordinance because it really does what the ordinance is trying to do, makes the house fit in with the neighborhood, saves the trees. And at this point, we're just going to ask that you grant the variances, and we looked at the 3 conditions that the staff has included, that if you granted the variance with those 3 conditions, we have no problem with that. And that's all I have for right now. I'll sit down and shut up for a little bit, and Mr. Kane just has a few things to say. Appreciate it. Do you have any questions for me at this point?
Do we have any?
We'll wait till after the applicant.
Good morning, ladies and gentlemen.
Good morning. Could I get your name and address for the record?
My name's Kenny Kane at 190 North Timber Lane, New Smyrna Beach, Florida.
All right.
If you can just go right to the next title slide, it'd be fine. There you, I'd just like to express how important this is to my wife and I. We're both natives of New Smyrna Beach, Florida. We were born at Fish Memorial Hospital. We raised our kids here. Our kids are raising our grandkids here. And New Smyrna is our hometown. And you don't see a lot of that around here anymore. But, you know, we're not trying to get away with anything here. You know, we've seen everything that's gone on in the past 50 plus years. I might be dating myself here a little bit, but we want to preserve the character of the neighborhood as well. If you want to go through a couple, this is the home that we're currently building. It's a Craftsman style. We're very proud of it, you know, and we're building it on this beautiful piece of waterfront property that we've you know, taken a lot of care to make things look right and to fit into the neighborhood, which is a great little neighborhood too. We really love it. So the last thing that we want to do is to build something smack dab in the front of the house. But because of the A3 zoning, it's you know, these setbacks are so far for us to be able to do anything other than in front of the house. If you go to the next slide, go to the next one now. As you'll see, that pole is almost in the center of the property. Again, we've tried to have it moved. I worked for 3 months with the city with the Utilities Commission to try and get this pole moved. It's because this pole services the house across the street and then the property back in the back. You've probably driven by there, Mr. Feller. It's a very difficult. And it's not that it can't be done, but it's about $30,000 to $35,000 to do it. And they really, the Utilities Commission really didn't want to have to do it. And you see, it's a beautiful pole. In fact, there's 2 of them. So you might ask, well, why not just put the building on the other side? Well, again, that puts this accessory building smack dab in front of the middle of the house. Go to the next slide. As you see, this community, this neighborhood it's isolated. It's in the middle of the Door Sleeper Preserve. There's not 600 homes around us. There's not 100 homes around us. There's 16 houses in here, and they're all unique, and they've been there for many, many years. I talked to the neighbors in the neighborhood, and they're all wonderful people. The one across the street's been there 40 years. They've been there 30 years, and they really like what we're trying to do there. They've told us how you know, we're not just coming in and trying to run over everybody. It's just we're trying to build a nice house in this nice area. And you know, I have this need for this building because I have a boat, I have an RV, and I can't get out of that property with where that pole is, with where I would need to put this building. I've tried it. I've done my due diligence. I've taken my truck and I've tried to put it where I would have to put this driveway to get out, and that pole is in the way, and then across the street is the other people's property. It's only, and their mailboxes there. I don't want to have to ask them to move their mail, and I would be having to drive on their property to begin with anyhow. And then if you want to go to the next slide, please. I just put this little slide together. This is just all of the places in the neighborhood on this chart, and each one of those highlighted areas doesn't meet the A3 requirement. And on some of these properties, so out of the 16 parcels, only 2 meet the A3 requirement. That's 2778, and then there's a vacant lot on the corner. You also notice that 10 of the 16 parcels miss all 3 requirements. And to add to that, 8 of the 16 parcels have a setback of 10 feet or less. You know, I've done my homework, I've done my due diligence, and I just ask that you look at this situation from our perspective on what we're trying to do here. And again, we don't want to be a distraction or disruptive to the neighborhood by these buildings. I appreciate your time.
Thank you, sir. Any questions for the applicant?
Yes, I have one.
Mr. Costa?
How long have you lived at the property?
It's under construction.
So you haven't lived there. How long have you owned the lot?
6 years.
6 years.
Took me 11 years to buy
So
it.
you didn't own it in 1992. You've owned it 6 years.
Correct.
So you knew what the zoning was when you purchased it.
Yes.
And the setbacks when you purchased it. Correct?
I knew what you know, I'm kind of a layman.
Understand.
I'm
trust me,
I've
just trying to
learned
clarifying a point that was made up earlier, so.
I've learned a lot in this process, I will tell you.
Understood. Okay, thank you.
And that's why I have Mark, because I don't understand the whole process either.
Got it. Thanks.
Mr. Bender?
Question, for the garage, which is variance 1 that we're doing, where's the driveway? I mean, is it going to be within that 11-foot setback area? How do you get
No,
to
the there will be a driveway over on, so if you look where that garage is, that's the west side of the property. There's a driveway on the east side of the property that I will access through there. But it comes all the way down the side of the property. It's already there. It's been there. It has a tree canopy. So that's how. And by the way, the house doesn't have a garage. That is the garage for the house, that detached garage.
So your driveway is in no way impact this 11-foot setback that you're requesting for either building?
No, sir, the driveway is on the other side of the piece of property.
Mr. Feller?
Not for, but for staff. We want to wait.
For me?
Chairman, if I could just clarify, the driveway for the proposed storage building would be right in front of it. I thought
Yeah, you'll see that on page 14. I'm sorry, the
driveway would be within the, if you look on page 14, you know, the proposed driveway, RV and boat storage. The proposed driveway, if you look on page 14 to 30, you see the proposed driveway there for the RV and boat storage area. And that would have, I don't believe that has to meet the setback, but it's probably 15 feet from the side yard.
Right. Yeah, I recognize that. I'd seen that. That's why I was just inquiring about the garage, because I could not see
And then on the
an
other
access point for it.
Yeah, on the
this
other
point.
side of we don't have that shown in here, but there's an existing driveway that goes around to the front of the house and then goes to the 2-car garage.
Okay. Thank you.
Also, I just wanted to point out that, so on this west side of the property, the homeowner closest to what I'm trying to do here is the one that wrote the letter of that he doesn't have a problem with what I'm trying to do at all. Thank
Do we have that letter? Okay. Mr. Young?
Yeah, I was there. I've been by there too, but the only problem I've got is I'm familiar with the area because I worked for the utilities and lived in New Smyrna too, but did you take these two things into consideration before you started building the house? I mean, it looks to me like you could have built the house in a different manner and these wouldn't have been in the way. I'm just wondering if you thought about these buildings as an afterthought. Because,
Well, if you'll notice, the house is shoved as far to the east as almost possible. It's a 25-foot setback. I'm at 28.9. So I tried to keep things where I would keep them out of the way, but it's just, with that power pole out there, it's just basically impossible to.
yeah, but, well, I could see where the house could have been designed a little bit different and you would have been able to move that. That's what I was just wondering, is if you took those into consideration before you even start building the house.
Mr. Chairman, if I could also point out that the reason the house on the west side is 40.5 feet from the property line is because there's a historic tree right there that we had to keep away from.
Okay. Mr. Feller?
I'm going to just ask it from staff really quickly. And the letter of support, I saw that was page 22. It looks like you've stayed away from Spruce Creek entirely. You're not in the resource corridor for your house, for
Exactly,
anything.
exactly.
And normally these would have an environmental permitting side to it, like that, whether they agree or disagree with the variance. But is it because there's no impact to the environment, to the resource corridor on this particular one? I mean, usually environmental permitting or environmental weighs in on it, but is that?
They always weigh in on all of our variances. In this case, they were pleased to see it away from the waterway.
Am I?
Any other questions for the applicant? All right, sir. We'll see if do we have any public participation for this case? Anyone like to speak to this case? Hearing none, we're going to close the floor for public participation and open up for commission discussion or motion. Go ahead, Mr. Feller.
In case V22-123, I move that we approve variances 1 and 2 for both accessory structures with the staff recommended conditions as they were, they said it was
Three conditions.
3 conditions.
Okay.
Second.
Okay, I've got a motion from Mr. Feller to approve V22-123 variances 1 and 2 with the 3 staff recommended conditions from Mr. Feller and a second from Ms. Shelley. Any discussion on the motion? All those in favor signify by saying aye.
Aye.
Any
Aye.
opposed? Motion carries unanimously.
Thank
you. All right, Ms. Shelley, can I get the
Thank you very
next
much.
case, please?
Yes, sir. Case number Z22-124, rezoning from the rural residential RR zoning classification to a rural agricultural A2 zoning classification.
Thank you, Ms. Shelley. Mr. Chams, this is you also. You're busy today.
Good morning again. The applicants are seeking to rezone their properties. They have three parcels. 2 of the parcels, I'm going to refer to them as 190 and 191, are currently zoned RR, which is rural residential, and 1 parcel, I'm going to refer to as 122, is split zoned as rural agriculture A2 and RR. The applicant's home is located on parcel 190, which I believe is the parcel closest to the road of Doyle Road. And the split zone property is the triangular one on the south side. The applicants are requesting a rezoning to A2 to develop the parcels with a garden for the applicant's business, which specializes in boutique flowers and vegetable seedling. The surrounding properties are large rural properties, zoned RR and A2, generally with single-family homes. They're pursuing the A2 for all parcels because of the agricultural pursuits of their business, and it would also permit their existing home. A2 zoning is conditionally compatible with the existing urban low-intensity future land use, so it's compatible in that regard as well. We don't expect any negative impacts on the environment or surrounding areas because they're not really increasing density. And the business will likely have a positive impact on the area's economy. So staff recommends forwarding to County Council for approval. I'm
Thank you,
available
Ms.
for comments or questions.
Thank you, Mr. Chams. Mr. Feller.
I just have one question. Do we know if the existing home meets the setbacks for the new zoning, or are we going to have future?
Oh, it does. It's fine.
Thank you.
Any other questions for staff? Is the applicant present? Good morning.
Good morning.
Name and address for the record, please.
Alicia Johnson, 395 Doyle Road, Osteen, Florida.
Okay, you've heard the staff report. Anything you'd like to add to that or make a comment on?
Nope, they did a really thorough job and were very pleasant to work with, so I really appreciate all their work.
Okay, let's see if we've got any questions for you. We don't have any, so let's see if we got any public participation. If not, we'll close the. We don't have any public participation on this case. Okay, anybody who would like to speak to this case? We're going to close the floor for public participation and open up for commission discussion or motion.
Be glad to make a motion.
Go ahead, Ms. Shelley.
Move that we forward the rezoning application case number Z-22-124 to County Council for final action with a recommendation of approval.
I've got a motion to forward the rezoning application case Z-22-124 to County Council for final action with recommendation of approval from Ms. Shelley and a second for Mr. Sixma. Any discussion on the motion? Hearing none, all those in favor signify by saying aye.
Aye.
Any opposed? Motion carries unanimously. Ms. Shelley, could I get the next case, please?
Yes, sir. Case number V-22-125, variances to the accessory dwelling unit regulations on a rural agricultural A2 zone property.
Thank you, Ms. Shelley, and this is Mr. Hanson.
Yes, sir. Give Steve a break here for a bit. Variances for this particular, or the variance request for this application are to cite a accessory dwelling unit on the property. We have two to consider. Variance 1 deals with the fact that the proposed location of the accessory dwelling unit is going to be located forward of the rearmost point of the principal dwelling unit on the property. The second variance deals with the actual size, exceeding the size ratio requirements of the ADU regulations, which limit an ADU to be limited to no more than 50% of the living area of the principal dwelling unit on the property, up to a maximum size of 1,200 square feet. The particular property is a legally non-conforming parcel. It's 4.91 acres. The proposed location for the accessory dwelling unit, as required by the accessory dwelling unit regulations, does meet all the required setbacks for the zoning classification. So after speaking with the applicant, I was told by the applicants that they started the process to develop the ADU back before our ADU regulations were adopted in July 2021, when the county still operated under the guest house and the garage apartment rules before we reorganized that under the accessory dwelling units. So with the proposed ADU, it meets the requirements of the time for a guest house. And looking at the plans for the proposed ADU, it shows the kitchenette and everything as well. So it seems to match with what would have been the required rule of the land at the time. However, we didn't actually get a building permit application for the proposed ADU until April of 2022. So it's a number of months after the ADU regulations were officially adopted by County Council from July of 2021. One thing to note, with setbacks, because we're looking for the front yard, the proposed location of the ADU, even though it's forward of the rearmost point of the principal dwelling unit, it's proposed to be sited back 124 feet. And you can see it on the variance site plan here from the actual road. There's a number of, a large portion of dense vegetation and trees on the property. And part of the reason for the applicant's choice of the location was because of a clearing area in the proposed location. So they thought that would be an ideal location because it would help minimize the need for clearing other portions of the property. As far as analyzing the criteria for granting the said variances, staff made the recommendation for variance 1 that it failed to meet 3 of the 5, noting with input that under criteria 2, the location of the proposed ADU is entirely the decision of the applicant, so they weren't even able to meet the not pursuant to the application or the results of the applicant. Variance 1, although the property is legally non-conforming under A2, under the third criteria, they're with having 4.91 acres, staff made a determination that the proposed ADU could still be located on the site without need for a variance to the actual location, so it could theoretically be sited behind the principal dwelling unit. As far as variance 2, dealing with the size, the proposed accessory dwelling unit, as you see in the variance site plan, is 1,126.25. So as far as the math, we rounded up to 1,127 square feet. Per the ADU regulations, the maximum size of an ADU would allowed in this particular property would be 854 square feet. And that's because of the ADU regulations allowing the 50% criteria, where staff measured the principal dwelling unit's living area at 1,707 square feet. As we subtracted the space for the garage, that created a ratio of 66% of the living area. Had the principal dwelling unit been larger, as far as having a larger living area, the proposed size of the ADU would have still been under the hard maximum of 1,200 square feet. However, because of the size of the principal dwelling unit, that's why we're looking at variance 2, is dealing with the size. We took a look as far as the criteria for that, is that it didn't necessarily meet the criteria 1, as the process for the adoption, even though the applicant stated that this particular variance was designed under the guest house regulations, we didn't have a hard record that staff was able to identify and find that a process had been started. During the pre-application meetings, the staff met with the applicant a number of times. Subsequent to the pre-application meeting in this day, and looking over a review of the actual submitted building permit applications, that building permit application didn't happen until April of 2022. The applicants, as far as whether or not it's the minimum variance necessary as far as the size, the applicants could theoretically have an accessory dwelling unit if it was at 854 square feet as opposed to the 1,127 square feet of the drawing. However, after speaking with the applicants, they had purchased the accessory dwelling unit ahead of time to have the company constructed, and it's being stored in a warehouse from my understanding, pending the outcome of this particular variance. I'm available for any questions the PLDRC may have.
Thank you, Mr. Hanson. Any questions for staff? Hearing none, is the applicant present? Good morning, sir. Could I get your name and address for the record?
Good morning. I still think it is Daniel Dolash, 2174 South Spring Garden Avenue, here in DeLand, Florida.
All right. You've heard the staff report. Anything you'd like to add or comment on?
Absolutely. Thank you. I couldn't have explained it better, Mike. But I did want to turn around. These are my parents, Gene and Judy Dolash. May or may not know my father. He's into a lot of things here. Here in DeLand, in the chamber and whatnot. But backing up real quickly, my parents were missionaries serving for over 35 years, and he still serves at a funeral home, people in their worst times. And it was with our goal and our mission objective, being residents for 20 years in Deltona, along with them in their home too, to move to a place like this in order to bless them and honor them for the remainder of their days. So we went ahead and sold our houses. We first moved there with the intent, well, before even purchasing the property there, it was with very careful consideration that we follow guidelines, dotting every I and T, making sure everything was set forth correctly. So without knowing setbacks that came up just recently, we weren't aware of what had happened in July, because there was a lot of determinations of what they would like, and then those standards and within the property and what we could and couldn't do. So we were in quite a bit of shock when we got this notification. So those 5 points would have been nice to have gone through, because there is, even though there weren't records in the computers, had been there over a dozen times within the last year and 9 months or so. And so with that in mind, there's no way to track that, but I know if we had known that, we probably wouldn't have moved forward in the same way. But we were relying on the communication within departments back in July. We knew that, and we had these 5 numbers of criteria set before us, and we knew about this change in policy. We wouldn't have stepped forward and invested in the cabin they have. So it is a financial hardship for them now. Henceforth, we cannot wait if your answer is no for another year. So it would provide more hardship in storage costs and whatnot, and deterioration of materials said. So if anything, I'll put out here a continuance on Plan B, if that will actually happen. My concern is, are we able to bring up the picture, Mike? Are you able to get in close to the very front where that is going to be in perspective to the primary dwelling? While he's doing that, when you're driving by on South Spring Garden Avenue, you're now going to see, since we moved in, development, residential development, which was not one reason we did want to get away from Deltona, was for that same reason. As a development, as Deltona grows, we want to get away to a place like we're at. Now we're seeing a lot of the affordable housing encroaching on us. So we're hearing this going on and wondering what's going wrong. What's wrong here? This is our primary dwelling. We don't have other property. This will be their primary dwelling as well. So if you're driving by, you are not going to see the primary dwelling. You're going to see a beautiful cabin on an acreage of very well cultivated grass, 4 acres of cultivated grass and beautiful trees. So as far as the perspective to the neighbors and the working relationships we have, they're aware of what our mission objective was and is still, and having my parents live there. And they're very happy about it too. I'm not sure if you've gotten any public notices, but I highly doubt it, because I got quite a few calls from them after we sent those letters out. So it's with my my utmost petition to you that you see this a little differently, because everyone is very unique sitting here listening to all these stories, but ours in particular may not meet those criteria now that a variance is being required. But we were hamstringed in a way, not knowing what was happening behind the scenes, and wish that we would have been informed back in July with my visits on their behalf to know that this was actually going to take place when we actually did invest. That's all I have.
Okay, any questions for the applicant? When did you purchase the property?
December of 2019.
Okay. So you'd purchased the property before the rule had changed, correct?
That is.
All right, sir. Let's see if we have any public participation. We got all. Okay. We'll go open up commission discussion, and thank you, sir.
Thank you.
Do we have any? We don't have any public participation. Does anyone like to speak to this case? All right, we'll close the floor for public participation and open up for commission discussion. Mr. Feller.
Yeah, I'd like to make one mention. When he said he learned about this in July, with the July, and I remember I was on the PLDRC when we voted for the ADUs, and it's long to vote on an ordinance changes and all that stuff. I didn't even see that the requirement was behind the house. But Mr. Costa had mentioned something when we were talking about size of properties, and we were going to come back to this because somebody wanted it a little bit larger, and then we we talked over size, and then went to county council. An unforeseen on this is everybody was thinking 50 by 100 lots and where are they going to put their little ADU. Now we get to 4-acre properties, and we're trying to tell this person to cut down trees and put it when there's a very viable spot that happens to be in front. So I'll say this from a commission standpoint. I think Mr. Costa called this one right when that ADU ordinance was passed. We're going to hear a lot about this because not every property in Volusia County conforms to that front back. We've already heard one in front of the PLDRC where their cabin was in front. So I hope we'll look at that, staff, maybe in the ADU as we move forward there. But I know there was a lot of discussion about the size, but 1,700 and an 1,100 square foot property on 4 acres compared to some of the stuff that's being built.
And Mr. Feller, every property is unique. It was designed for traditional neighborhood type development. So something like this. Normally, I wouldn't say the size of a lot is a consideration. Here, because it is tied to the location, behind the rearmost point of the house, you can consider how big of a lot you're actually dealing with. And, inadvertently someone located their house on this 17-acre parcel, 17 acres? Yeah, very far in the back. So that is something you can consider as, these locational criteria for this type of variance.
And that's another reason I think why our board exists, so we can look at these cases individually. So I think Mr. Feller's ready for a motion.
I'd be happy to make a motion on case V22-125 or variance accessory dwelling unit regulations, that we approve variances 1 and 2 with the staff recommended condition.
Yes, sir.
Yes.
Yeah.
Okay. Condition.
Yep. Second that one.
Okay, I've got a motion to approve variances 1 and 2 for V22-125 with the one staff recommended condition from Mr. Feller and a second from Mr. Sixma. Any discussion on the motion? Hearing none, all those in favor signify by saying aye.
Aye.
Any opposed? Motion carries unanimously.
Good luck.
All right, Ms. Shelley, can I get the next case?
Yes, sir. Case number V-22-126, variance to the minimum yard requirements on urban family residential R9 zone property.
Thank you, Ms. Shelley. Mr. Hanson.
Thank you. Michael Hanson from Planning once again. With this particular property, we are at once again in the Bethune Beach area, and we're looking at 2 variances for that proposed addition to the second-story balcony. One thing to consider in particular, that this property was subject of an approved variance back in 1983 with variance B 83-B036, which reduced the minimum required front yard setback in the R9 zoning classification for the property from 25 feet to 6.24 feet to allow the property to be developed with single-family residence on it. It is a legally non-conforming parcel to the R9 zoning classification, as R9 requires typically 7,500 square feet with a lot width of at least 75 feet. And with the construction of the property, we have a section of our code under section 72-277 that allows roof overhangs, unenclosed balconies or stairways to project and encroach into a yard up to 3.5 feet or half the setback, whatever's less. So the original balcony met that criteria. Now, after discussing the proposed reconstruction and redevelopment of the second-story balcony in the front yard with the applicant and the owner of the property, they're looking at extending it out another 2 feet, which would exceed that allowed overhang and encroachment into the front yard setback for that accessory structure. So that's what's prompting the actual first variance. During review of the site plan and staff calculated out the lot coverage as under the R9 zoning classification, it allows up to 35% lot coverage. With the proposed 82 square feet addition to the front yard balcony on the second floor, we'd be looking at 41.88% lot coverage. So the lot coverage is exceeding the maximum allowed lot coverage as is without that addition to the balcony. Speaking with the applicant and the owners, the proposed, the justification that staff was given as far as why this is necessary, it was to allow disabled resident to have access to the second floor balcony. Now, one thing to take into consideration, from the edge of the property line that you can see on the site plan here, there's a measurement of 14 feet from the traveled way along South Atlantic Avenue. So with the proposed encroachment into the required front yard setback, we'd be looking at reducing that front yard setback to essentially 1.24 feet. So you'd have 15.24 feet from the traveled right of way to take into consideration as well. As far as the evaluation for the criteria, staff made the recommendation that this had failed 5 of the 5 criteria, and for both variances, requests 1 and 2. And under the review, we understand that the special condition in the circumstances for a disabled resident on the property that has an inability to access the balcony. However, the condition relates to an individual person, it's not particular to the land, building, structure, or sign. So that was why that particular criteria didn't meet. The 35% lot coverage aspect, it's already exceeding at a little over 40% thereof, and increasing to 41.88% would be a further increase of lot coverage, and there wasn't a special condition or circumstance that necessitated that increase of lot coverage. The proposed reconfiguration of the balcony is entirely in action of the applicants. One thing to take into consideration as you look on the site plan here, there is a substantial wood balcony surrounding the entire property that feeds back to a 12-foot deep wood deck on the second floor. There's also a wood balcony / deck on the third floor as well. So there are areas for individuals to access the balcony as well on other portions of the deck besides the particular front yard. And that was the main reason why staff felt criteria 3 as well. And because of the location of the existing decking already, the staff made the determination that this isn't the minimum variance necessary to make a reasonable use of the land. The previous variance granted back in '83 would be an example of a minimum variance to make a reasonable use of land because it allowed the development of the house in the first place. One thing to take into consideration with this being in the R9 zoning classification, Bethune Beach, it is subject to the Indian River Lagoon Surface Water Management Improvement Overlay Zone. So it is required to have 35% lot coverage, or 35% of the lot to be reserved for on-site stormwater retention, and also natural native vegetation. So that's would be something that can't be adjusted here at this meeting. It's be handled actually at the permitting level. I'm available for any questions the PLDRC may have.
Mr. Feller.
I do have a few questions. One, you're saying that the current house already exceeds the 35%?
That is correct. The current house, inclusive of the elevated decking that they have on the particular property.
Inclusive. And that actually stems to my next question, and maybe this is a bigger question, can't be answered today, but we do our lot surface area and our setback, not just from the part that touches the ground, but the overhangs, et cetera. And not all counties do that. Do we know that there's an environmental impact. Is there any difference between denoting surface area above or that touches the ground when it comes to runoff and things like that? I didn't see anything environmental on here.
Not to speak for them, but the runoff provision is more of a surface water, stormwater discharge. It goes to your impervious surface area, and that's usually handled through engineering, site planning, grading work. For an environmental impact, it doesn't matter because you're impacting whatever natural resource and vegetation is there, regardless of whether it's elevated or kind of slab on grade construction. So, you're impacting, there's a wetland buffer. If you cast a shade over it, or if there's wetlands underneath there, you're still impacting it from an environmental perspective. Probably not true from runoff and pervious surface and impervious surface. That's why it's building coverage and not impervious surface is the criteria that you usually deal with, because we're not as concerned with stormwater and perk.
Because that was my next, was there usually, like you said, there's environmental that chimes in on whether this is okay or not, and I didn't see anything from environmental on this. But then my only other question might be for the applicant at some point, but in the red, is the only extension is on the front side of the property, correct?
That's correct. If you look on the variance site plan, the hatched area on the left-hand side is the new area.
But, and it was said that there, and again, maybe this is a question, this will be a question for the applicant. Thank you.
Any other questions for staff? Okay, I see the applicants here. If you state your name and address for the record, sir.
Yes, James Fowler. My office is at 28 West Central Boulevard in Orlando, Florida. And I'm the applicant, the property owner. And what we're asking, and incidentally, the handicapped person was my wife's mother, who's since passed away, and she couldn't access the deck with her walker. So I guess I'm the next one on the list to be able to need something like that, but not right today anyway. What we are asking for is the ability to extend the deck a little bit, cantilever it basically, because it won't extend to the ground. It'll be approximately 18 feet in the air over the roadway. Why? Well, a couple of reasons. For whatever reason, the property west of our home is vacant, virtually all the way to the river. So you can go out and spend time out there and you get to see things like that. But the second, and to me the more important reason, because I like to go out there with my dog. And they're really, really a large dog. So I go in the evening and the afternoon when people are typically walking by. And it gives me a basis or them a basis for broaching a conversation. So I get to meet the neighbors, or because there are quite a number of people who rent properties up and down the street, I get to meet them because, what kind of dogs are those? Oh, can we come and look at them? And it just becomes a very pleasant way to spend some time. Problem is that, as the staff has indicated, the existing deck is very narrow. And it was built, I guess, 40 years ago now. My involvement, I guess, was purchasing the home 10 years ago. So what I would like to do is extend the cantilever out a couple of feet so that there's room for me and the dogs. And if I wanted to put a chair down, but you can't do it now because it's so narrow, you would virtually block the entire walkway. If you look at the pictures, and you all have these same pictures? You can see the house, which is the lighter roofed house. You can notice the property across the street is vacant, but you can see the home to the north of me. It's slightly farther west than my home, and then its deck extends out substantially farther. So it's not like I would be unique. Actually, I'd still be well within inside the adjacent property. And candidly, if you go up and down the street, this wouldn't be particularly unique at all. I'm not going to identify the properties, but if you were to drive up and down the street, you'll see that most, if not virtually all of the properties are relatively very close to the roadway. Not all of them, but I would say a majority of them. Certainly from my property to the south. So it's basically a convenience thing. It's not the end of the world. I think it will make the home and more entertaining and enjoyable for my wife and my children and my grandchildren now, who like to spend time there, and it's as simple as that. And I'll answer any questions you might have.
Any question for the applicant? All right, sir. Let's see.
I will add, if I can, Mr. Chairman, a couple of the items that the staff identified, like the actions don't result from the actions of the applicant. The only action I had here was buying the property. So if that's the action that they refer to, then I guess I am guilty.
All right, sir. Let's see if we have any public participation. If we do, I'll give you a chance for rebuttal. If we don't, we'll close the floor. Do we have any public participation? Anyone like to speak to this case? All right, you can have a seat, sir.
Thank you.
We're going to close the floor for public participation and open up for commission discussion. Any thoughts on it? I'm not a big fan of...
I would say that I know that area and I went by it, and I don't see any problem with another little couple of feet myself. There's a lot of them with a lot of bigger decks.
The only problem I have is the 1.24 feet. That's awful close.
And again, my only problem comes down to the land coverage, especially on oceanfront homes. We're now at 41.88% coverage, and now it just, I know we're looking at each one individually, but what happens is then all of a sudden it becomes character of the neighborhood in cases down the road where everything's 41 point or whatever. So that's the only one that I'm really hung up on is that we're there, but you're saying it's already at over 40%. So I'm torn on this one. I really am, especially.
I'm going to ask Mr. Hanson. It says the required is 6.24. What's the existing now?
So with the granted the variance back in '83, it reduced that required front yard of 25 to 6.24. So the front yard setback is 6.24, and that's what the house was developed at. So the existing 3-foot overhang encroaches into that, but that's allowed for our accessory structure section of the code.
Okay, thank you.
Again, I drove by it. I know the house next door to it does have, and it's not cantilevered, it's actually into the ground. And I saw that, and I think to myself, poor gentleman is kind of caught between a rock and a hard place with some of our code with it. But so I'm having a tough time.
Yeah, there are some of them right along there that when I drove that go right to the ground. They're not cantilevered. That was my thought.
So we keep on for one goes in, and the next one keeps on getting closer to the road. That's what you're pretty much saying.
But the house itself, and that's where we vary. This county varies from others, that they count the balconies which are not actually touching the ground as square footage, where the actual footprint of this house is not encroaching to 1.3. It's the cantilevered overhang. And if we were talking down below on the first level, I would have my vote would be completely different. But being up on a second level as a cantilevered balcony, I don't see any issues here.
Mr. Costa, I agree with you on that. And also, I think we just had one over on Ingram that was the same way because he had his plans drawn in orange versus here. So, I mean, as much as I like to protect this area, I feel like this is not as, I mean, we're not digging in the ground. We're not putting posts in.
I don't see that this gentleman should be deprived of this particular right.
If there's any other discussion, I'm prepared.
Okay, go ahead.
All righty. And V22-126, request variances for the minimum front yard and variance to the maximum lot coverage. I vote that we approve with the staff recommended 2 conditions.
I'll second that.
Yeah. Okay, I've got a motion to approve V22-126, variances 1 and 2, with the 2 conditions from staff, from Mr. Feller, and a second from Ms. Shelley.
I used to play college bowls, so that, I hit that buzzer.
And, any discussion on the motion? All those in favor signify by saying aye.
Aye.
Any opposed? Motion carries unanimously. You're welcome. Okay, Ms. Shelley, can I get the next case, please?
Yes, sir. Case number Z-22-127, rezoning from the prime agriculture A1 and transitional agricultural A3 zoning classification to transitional agricultural A3 zoning classification.
Thank you, Ms. Shelley. Mr. Shand? This is, yeah, Mr. Shand.
Good morning again. The applicant has a parcel that is split zoned A1 and A3. They wish to construct a single-family home on the property, but the property is non-conforming as it doesn't meet the lot area requirements of either classification on its own. Rezoning to A3 would resolve the nonconformity and allow construction to commence. Surrounding properties are A1 and A3 and generally rural in nature. Proposed A3 zoning is conditionally compatible with the rural future land use, and the approval of the rezoning is not expected to have any substantial impacts as it will be developed as a single-family home. Staff supports this and recommends forwarding to the county council for approval. Available for questions.
Is there any questions for staff? If not, is the applicant present? Come forward, please. Would you give us your name and address and anything that you want the board to consider?
Yes, my name is Kim Blick at 1202 Hickory Lane, DeLand. I'd like to build a single-family home on the property, and the way it's zoned at this point, can't build.
Are there any questions for the applicant? Is there anyone want to speak to this case? If not, we're going to close the public hearing. Thank you. And we're ready for a motion or discussion.
I'm ready to make a motion. I recommend that we forward the rezoning application, case number Z-22-127 to County Council for final action with a recommendation of approval.
It's been moved and second that we forward application Z-22-127 to the County Council for approval. All in favor? That signify by saying aye.
Aye.
Any opposed? Motion carries unanimously.
Hey, Ms. Shelley, can I get the next case, please?
Yes, sir. Case number V-22-129, a variance to the maximum fence height requirements for urban single-family residential R4 zoned property.
Thank you, Ms. Shelley, and this is Mr. Shams again.
Hi, good morning again. This variance is for maximum fence height on a corner lot and R9 zone property. The variance is for the southern frontage of the home. They're looking to have a 6-foot fence along Evergreen Road. This is a typical corner lot, and there was not a special condition to justify the variance. A 4-foot fence would provide privacy and a barrier to observe trespassers. Staff recommended denial as this didn't demonstrate a special need or justification. If the PLDRC finds evidence for approval, staff recommends one condition, that the variance is limited to the structure's size and location on the variance site plan. Available for comment or question.
Thank you, Mr. Shams. Any question for staff? Is the applicant present? Good morning, ma'am. Could I get your name and address for the record?
Good morning. My name is Elaine Capron. I reside at 205 West Parkway, DeLand, Florida.
Okay, you've heard the staff report. Anything you'd like to add to it or make a comment on?
Yes, I went through the report, but first, can I just give her pictures for you?
You sure can. They get to keep them. It becomes part of the record. They get to keep these pictures.
My beautiful grandchildren are in there. That's fine. I went through the findings, and there were a couple of things that I'm pretty sure you guys are not aware of. When we purchased the home, it was already being built. So I didn't just purchase a piece of property and ask somebody to construct a particular home where I would go look at variances and what's necessary. What we did was we bought the house that was being built unseen, and we got to see aerial shots. The aerial shots that we did see were different properties in the neighborhood that had 6-foot fence, namely my backyard neighbor, who has the exact fence, except for it's wood. We want to put vinyl because I think that looks more aesthetic. He has the exact fence along the same exact road that I'm trying to put up. And his children actually gets to enjoy their backyard with privacy. I get to see their little balls going across, you know, and they enjoy that. So I didn't buy a property that was being constructed. I bought something that was already there. God just blessed me with it. The other thing is that while the zoning does provide for 4 feet, 6 feet actually by Forbes.com is what is the standard for privacy. 4 feet is for small animals. When you drive into our neighborhood, it says, mind your small animals because we have bears. The other thing is that I have 8 grandchildren who are very small, but they become very tall. And I like to allow them to run around in their backyard when they're with us. 4 feet, 8 grandchildren. If you have grandchildren, you know you can't keep up with 8 of them. 6 feet, I don't have to worry about them reaching locks to unlock the gate. I don't have to worry about them in the backyard. They can enjoy themselves. And I definitely don't have to worry about them playing kickball because it's not going over a 4 feet fence into the canal. The other thing is, one of those pictures actually has a picture of my kitchen window. You can see directly into my house with a 4-foot fence. There is no privacy. I'm looking to put the 6 feet for privacy. The last thing is my husband is a truck driver. And I have already experienced seeing somebody at my window while he's away, which is why we put up security. But the cameras are not an inhibitor. It's really just there so you can see what happens. I don't want to be the statistic that something happened and I didn't take care of the problem. So that 6-foot fence, it literally does create an avenue of safety, privacy, everything I need that's necessary. It doesn't cause anything to, you know, it doesn't cause anything to look unseemly in the neighborhood. There are people, we took the time out, we drove around up and down the whole road, and we took pictures of people with the same house, almost, and they had a 6-foot fence along the same road. And there's one where they had a 6-foot fence in the front and in the side. I'm only looking to put a 6-foot fence on the side. And it doesn't extend all the way to what I call the front of the house, where the carport is and the front door is. So that is basically what I have to say.
Okay. Do we have any questions for the applicant? Yes, Mr. Feller.
One quick question. So in your site, there's a site plan here. The fence is going to come and then it'll adjoin to the house. Is that correct? It's not going to come past the front of the house?
No.
Okay, because I think the 6-foot fence usually on roads is for a line of sight. So if it's as depicted, it would come down that side of Evergreen and then it would attach into your house at some point.
Correct.
And not go any further to the road. Okay, thank you.
Just a real quick question and more comment than question. You consider your front door to be facing what road?
West Parkway, where the front door
You consider
is.
that your front yard?
Yes.
Thank you. That's all I needed to hear.
We run into this all the time with these corner lots. Okay, any other questions? We'll see if we got any public participation. If not, we'll close the floor and make a decision. No public participation. Okay, we're going to close the floor for public participation and open up for that motion.
I'll be glad to make a motion.
Okay.
And again, as we all know, it's that two front yards
Mhm.
problem that we have all the time. I'd like to make a motion that we approve variance case number V-22-129,
With the ones.
subject to one staff condition.
Okay, I've got a motion to approve V-22-129 with the one staff condition from Ms. Shelley and a second from Mr. Bender. Any discussion on the motion? Hearing none, all those in favor signify by saying aye.
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 Any opposed? Motion carries unanimously. Okay, Ms. Shelley, could I get the next case?
Yes, sir. Case number Z-22-133, a rezoning from the urban single-family residential R4 zoning classification to the conservation C zoning classification.
Okay, thank you, Ms. Shelley. Ms. Smith?
This case is regarding the Pioneer Settlement of the Arts. It is a site where we have a bunch of historic structures out there. They offer tours on their property. Initially, it was an old schoolhouse, which is now part of the tours, and the property was zoned R4. That's an old zoning classification. So we recognize now, as they're looking to come in for a new building, we are not allowed to approve a new building on the property because it is an old non-conforming parcel. And we are trying to allow them to do an expansion on their property to allow an old car group to come in and give historical lessons on the car industry. And that's going to be a partnership between the current owner and that group. So we looked at different zonings that would work to make this more appropriate, and the conservation zoning will allow them to put up this additional building and will allow this property to be used for its intended purpose. So we would recommend approval of this rezoning to conservation.
Thank you, Ms. Smith. Any questions for staff? Ms. Smith, that conservation zoning was the best zoning to get what we were trying to get here?
We ultimately settled on the conservation rezoning because it does accommodate the historic structures that are out there, and it does protect them. Another option we looked at was public, but we just felt like the conservation zoning felt a little bit better in this case. It has smaller setbacks, and it allows them a little more flexibility in this case.
Okay, all right. Okay. Yeah, Mr. Feller?
On that same note, the one thing I noticed was that there are no setback requirements for this, and there are 2 roads there. Does that bring any concern to the county? I mean, I didn't get a chance.
Not especially. I mean, let's see what those roads are. Are 40 and I think that area is heavily wooded. They are not immune from tree preservation, tree permitting requirements.
They're not immune?
They're not. So they would, that would be very costly if they wanted to encroach in that kind of buffer type area. So it's not so much of a concern. Additionally, it's for preserving the kind of archaeological site.
I just wanted to make sure there wasn't a concern from the traffic standpoint or something like that.
Okay. Is the applicant present? Can I get your name and address for the record, ma'am?
My name is Gudrun Benson. I reside at 4965 Upson Avenue in De Leon Springs.
All right. You've heard the staff report. Is there anything you'd like to add to that?
The Barberville Pioneer Settlement was established in 1976 as an adjunct classroom to Volusia County Public Schools and operated out of the old schoolhouse that was at that point still owned by the school board. In 2001, the school board turned the property over to the Pioneer Settlement, and since then, we have operated as an independent nonprofit organization, hosting anywhere between 9,000 and 11,000 school children every year, in addition to 27,000 members from the public that visit us for events, special events, and just casual walk-ins to enjoy the historic setting that we have created over the past 40-plus years. The rezoning would allow us to enhance the current setting with the partnership with the Crankenay Car Restorers Club, and bring that aspect into our established interpretation of lifestyle of pioneers and early settlers in the area. And it would also, excuse me, it would also allow us to enhance infrastructure on an aging property that is coming very soon, that we need to improve upon to accommodate our visitors.
Okay. Any questions for the applicant?
One thing I'll say, if you guys have never been there, I was there for a county leadership program a few years ago. That's an amazing place.
Thank you.
Yeah, I've been there too.
Good job around there.
Numerous times.
We hope to be able to build on that and expand our offerings and bring new aspects to our visitors.
Okay. Let's see if we got any public participation. If we do, I'll give you a chance to answer any questions or concerns they have. If not, we'll close the floor. Thank you, ma'am. Do we have any public participation on this? No? Anyone would like to speak to this case? Hearing none, we'll close the floor for public participation and open up for a motion.
I'd like to make a motion
Okay.
that we forward the rezoning application case number Z-22-133 to County Council for final action with a recommendation of approval.
I'll second.
I've got a motion from Ms. Shelley to forward the rezoning application case number Z-22-133 to County Council for final action with a recommendation of approval, and a second from Mr. Sixma. Any discussion on the motion? All those in favor signify by saying aye.
Aye.
Any opposed? Motion carries unanimously. Ms. Shelley, could I get the next case?
Yes, sir. Case number Case number O-22-134, ordinance 2022-24, nonconformities.
Thank you, Ms. Shelley. And Ms. Smith, this is you.
I am pleased to bring you this case. With the county's current regulations, we have zoning regulations and we have subdivision regulations. Those regulations require an additional burden on applicants if they have non-conforming lots to go through two separate processes. The first is the subdivision process, and then the second would be to separate non-conforming lots. This will greatly reduce the amount of cases that you've been seeing over the last few years, as in they will no longer need to come through the planning department to separate non-conforming lots. If it's a non-conforming parcel, they will still be required to get a non-conforming lot letter. However, if we find that the parcel or the parcel that it's connected to was illegally established through our subdivision regulations, then they do not require a variance to separate those non-conforming lots through the planning department. I'd be happy to answer any questions, and our attorney is here as well to answer any questions on that for you.
Okay, thank you, Ms. Smith. Any questions for staff? I know this has been on the table with us for quite a while. We've discussed this many a time.
I can say it's a good job.
Yeah. Well, if we don't have any questions for staff or their attorney, we'll go ahead and I'll entertain a motion.
I'll be glad to
Well,
make a
first of
motion.
all, let me see if there's any public participation. I'm sorry. Any public participation for this case? Anyone like to speak to this case? All right, now we'll close the floor.
I'll be glad to make that motion.
Okay.
That we approve, that we forward ordinance 2022-24 forward to the county council with a recommendation of approval.
I've got a motion to forward ordinance 2022-24 to the county council with recommendation of approval from Ms. Shelley and a second from Mr. Sickler, correct?
Costa.
Oh, Mr. Costa. I didn't hear you. I had no way to look at it. Any discussion on the motion? All those in favor signify by saying aye.
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 Any opposed? Motion carries unanimous.
Thank you.
Ms. Shelley, could I get the next case?
Sir. Case number 22-135, ordinance 2022-23, Southwest Activity Center permitted uses.
Thank you, Ms. Shelley. Ms. Smith, this is you.
Yes, this proposed ordinance is a bit of cleanup for the planning department. The Southwest Activity Center is designed through our comp plan to be a high-density development near I-4. It includes both commercial and residential uses. Our comp plan considered warehouses and distribution centers as well as smaller lot sizes. We brought forward an ordinance a few years ago to update our zoning code to match our comp plan. We did miss two things, and the property owner came in, met with our council, and pointed out two issues that created a conflict between the comp plan and the zoning ordinance. The first is in the commercial area of the SWAC. Again, just to add the term warehouse and distribution facilities that were already considered as part of the comp plan. The second is to reduce the lot sizes in the residential area for single-family residential homes from 7,500 square feet, which is more typical of urban low, and to allow for 5,000 square foot lots with 50-foot lot widths. And this came up as developers were trying to design projects and could not meet the density requirements and then the zoning requirements. So the county council directed us to come back and fix that error in our zoning code, and this is what you see before you now. So we would recommend that you forward it to county council with a recommendation of approval.
Thank you, Ms. Smith. Mr. Feller.
It's probably going to be more for discussion, but I went back and looked at the origination of this ordinance, and you said that it included warehouse and distribution centers, but when I read it and when I saw the original, it said warehouse, not distribution centers, and then they wanted that added in.
It's, the comprehensive plan provision had distribution centers as a use. The zoning did not include distribution centers. So you've got that kind of discrepancy where.
So it wasn't, because I did not see that in the comprehensive plan for distribution centers. I did see it for warehouse,
right.
But
it's,
because I also noticed that, permitted use number 38 is flex office warehouse facility, but now we're adding warehouse. So,
do you have a copy of the
and distribution center too, but I think that when I read it, and again, if you can show me something, sure. When I read it, I saw that warehouses was omitted or not put in there, not got in there, but then I saw it in line item 38, and now we're adding it. I wanted to just get that clarification, and then the rest I'll do when it comes to comment section.
And I've got a question on the density. Which established the higher density, the zoning or the ordinance?
So the ordinance, the comprehensive plan sets a minimum density of 4. It's 4 to 8 for single family. So the way that the zoning works is it set a minimum lot size that once you actually put everything on the ground, and you subtract roads, stormwater, required tracts, if you required a 7,500 square foot lot, you could never meet the minimum density requirement.
That's of the ordinance?
Yes.
Or the zoning?
Yes, the zoning was set up such that you could not meet the comprehensive plan requirements of 4 dwelling units per acre. You would always fall short of that, and therefore you couldn't have any single family in that zoning district.
Well, you could, but the density would be
Oh, no, no. you couldn't.
greater.
No,
Well,
because the
not-
minimum
not
lot
meet-
size,
Not meet
right?
the 4 units.
The problem is that you have a minimum lot size, so you can't go get smaller than that. So
Right.
so you can't actually get greater. You couldn't even meet the minimum, much less the maximum. So you could never get 4 dwelling units per acre with a 7,500 square foot lot once you layer in all of the required things.
Okay.
Can I add on to that, Chair?
Yes,
That was,
Mr.
it was
Feller.
going to be part of discussion, but since we're discussing it, that's another thing that I noticed when this came over to us was the recommendation in the residential section to go from 7,500 to 5,000. And I mean, if not a huge percentage of the variances we hear are all because these lot sizes are 50 by 100. And people say, I can't build a house on 50 by 100. And no. And now we're looking at zoning this as 50 by 100 houses. And I don't see the houses getting any smaller. I understand that it may not gel up with the comp plan as I'm looking into it, but I don't see why we're getting to that density. I understand why we're talking about it, but from a practical standpoint, very much against it.
So if I may, this is a little bit different situation in that this is an area that was targeted by the county to do very high-density development. It's an old DRI that has been around for 20 years, and the intent was always very dense development.
Right, I absolutely get that, and I think that, obviously we know that it's been vacated by all the parties on it, and now I'm just looking at it, and I'm sitting here saying, and again, we haven't heard from anybody. I did watch the county council presentation on this, so knowing a little bit about it, I'm looking at this and I'm saying, well, this is where the next Amazon facility is going to go then, because we're writing it up and then we're changing the density, and it looks like I just look at this and I see to myself cramping a lot into this area. So.
You're not changing the density. The density in this area is 4 to 8. So anyone who wants to develop single-family residential development needs to have a density of 4 to 8. They can't do that under the current zoning. So in order to achieve that, they would have to come in for a PUD, and that PUD would by necessity have to have smaller lot sizes to achieve that high density as required by the comprehensive plan.
Can I expand on that then? Are we not supposed to look at potential changes to the comprehensive plan when we're looking at ordinance changes? Or are we bound by what that comprehensive plan says?
You are bound by what the comprehensive plan says.
So the comprehensive plan dictates that we have to change this to 5,000 square foot so that they can build houses.
No, it dictates if someone wants to develop single family, then they must meet that density. They can't do it by the zoning that we set in place. If they follow PUD that says here are the lot sizes to meet the minimum density, that is a requirement. You can't force them to be lower than that because the comprehensive plan doesn't allow them to be lower than that.
So again, just to clarify, if we did nothing on that and somebody wanted to do a warehouse, they could, if they had the land over an acre or whatever, they could do a PUD for warehousing. Or
yes.
If they wanted to build a subdivision and they wanted to meet certain things, they could do a PUD for that. Or we could just blanketly open the whole thing up. Is that, I'm sorry if that's oversimplification.
It's allowing a use that's contemplated by the comprehensive plan in the zoning districts that are supposed to be on there. So, and speaking of that, I did find in the comprehensive plan where I talked about distribution. So under Southwest Activity Center Commerce, SWAC Commerce, under B, Light Industrial Business Park, the intent of this use is to provide for light industrial development and complementary uses. These parks may contain a variety of uses, including but not limited to warehouse/distribution, light manufacturing and assembly, research and development, flex space, industrial and business headquarters/offices, general/professional office, wholesale/retail showrooms, and incubator spaces for emerging companies.
The clarification on that, it looks like, yeah.
Okay, my other question was, why was this SWAC put in this zoning to begin with?
I think Trish mentioned this was part of an old DRI, so it was designed specifically for high density. when they were setting the, and I wasn't here at the time, when they were setting the minimum sizes, lot sizes for that zoning district, they may not have taken into account that once you have to put in all of the other things than lot sizes, you could never meet the minimum density. As far as the uses, I think it was just an oversight when they were listing the allowable uses in that zoning district. They may have inadvertently left out those particular uses. And the way that our code works, if that use is not in that zoning district, it's presumed to be prohibited.
I understand the usage. What I'm concerned about is the density in that area.
I mean, that was set by, I think it's a holdover from the old DRIs. The old DRIs set this kind of high density of 4 to 8 dwelling units, and set that as the minimums and maximums for single-family residential development. And when the county in 2018, I believe, set the zoning, they set a lot size such that when you actually tried to plan it out and construct it, you could never meet the minimum density requirements of the comprehensive plan.
But the old DRI never took into consideration of all the new high-density developments that are in place now.
Maybe, but I mean, we took the DRI standards and turned them into policy standards for development in there. So that, I mean, that sets the policy of development in that zoning district.
Mr. Young? Bender?
I have more of a comment than I grew up in the area, and there hasn't been probably not many times I've driven down that road and I said, damn, I wish I had a piece of this, just looking at it and knowing what's coming and supportive of it. The thing that concerns me with this is you never hear anybody talking about traffic. It's already a parking lot. So what are we going to do with all of cars, trucks, things when this all come to pass with these higher densities, things like that? That's what somebody need to start talking about, and talking about it loudly, because right now we have a serious problem and we're getting ready to invite that. I mean, like I said, there hasn't been a time I've driven down that road and I've said, I can see it, and man, I wish I had a piece of it. Pockets just wasn't deep enough to get in that dance. But somebody needs to start talking about traffic, please.
Well, this is what I'm saying. These old DRIs taking into consideration of the new, what has been put into place since then of the densities that we've experienced. That's where I'm going with it. Should we keep on pushing it in there? That's my concern. So, Mr. Feller.
And my concern goes the same way. I'm trying to figure out, I understand that the DRI said certain things and the DRIs have been vacated at this point, and we're looking at a comprehensive plan for what's the best use of the area in this, or this area. But
You're looking at a zoning, so the comprehensive plan is set. So the comprehensive plan sets, the minimums and maximums, and it actually has some trips, some vested trips from that old DRI that's kind of built into it.
Right.
I think there is approximately, like, for the Commerce District, 6,000 net external vested daily trips, and for the Community District, 5,000 net external. And if they exceed that, they have to mitigate that through some kind of improvement or proportionate share. But when they developed the Southwest Activity Center, they built in those trips into the provisions of when they set up these entitlements.
And I guess where I'm having a hard time is we're supposed to be looking at what's best for the county versus and what I'm hearing is we have to just meet standards that were set by somebody else when it came to densities and things like that, versus being able to look at it and say, well, I mean, if they're saying, I guess what I'm hearing is the county set these in place when they did the comprehensive plan, but failed, if you will, to take into account roads and trees and mitigations. No? Or, I mean, so then why can't they build on 7,500 square foot lots if it, you know, I mean, why don't the two things equal up, is I guess what I'm
Well,
asking.
when you develop a 7,500 square foot lot, you exclude your stormwater,
I
you
get it,
exclude your roads, you exclude your park tracks, you exclude your utility tracks and all those things. So, when you try to get 4 dwelling units per acre in an acre of land, there's not enough land to meet the minimum zoning area.
I get that. That's why I'm saying, how did they not then say, we shouldn't do 7,500 square foot lots and make it something else, and now that this PLDRC has to zone it down?
Well, that's,
I mean, if they set it at 7,500 lots and they did all that, and the computations came up and said, well, it doesn't work, why is
Well-
it our comprehensive plan?
well, it's
Is
because
that-
the comprehensive plan was set and the zoning came after. So the zoning kind of, when they did the calculations, didn't, it was set up such that you couldn't develop it. The alternative would be to lower the minimum requirements in the comprehensive plan to say 2 or 3 dwelling units per acre, but that turns this kind of area into a low medium density versus the contemplated high density. I mean, that's a policy decision by council, which we,
But it's
during
also
the discussion.
policy decision by us too, correct? I mean, we forward recommendations. Are we not allowed to have
Oh,
those?
you can.
Yeah.
So fundamentally, what's being asked of you is, should council approve the 2 things: adding in distribution centers and warehouses in this zoning district by right, and reducing the minimum lot sizes. Okay, if the commission says no, then you can provide, you know, that property owner would have to go through a PUD for the commercial uses, and you can recommend to council to lower the minimum density, you know, and that way you can have 7,500 square feet and you only need to meet 2 dwelling units per acre or 3 dwelling units per acre. But the comprehensive plan changes are not before this commission. You're kind of limited to commenting and your recommendation of approval or denial on the zoning changes.
Right, and so the county council, I mean, so we don't have the same 3 options that they have, which is keep things just as they are, allow these new changes, or we can't redo the comprehensive plan. I think those were the 3 options that were presented to
Yes,
county
you can do
council.
1 and 2,
You can
but
do 1
not
and 2,
3.
but not 3. Okay, well, that answers it. Good.
Okay. All right. Any other questions for staff? Okay, we do have some public participation forms on this case, and I'll start out with Mr. Fowler. Fowler, yes. Good afternoon, sir.
Good
We
afternoon.
made it past the noon hour.
Good.
Could I get your name and address for the record?
My name is Thomas Fowler. I have 1506 East Wisconsin Avenue in Orange City.
Okay, and you had a comment to this ordinance?
I have a lot of comments.
Well, unfortunately, we got about little over 2.5 minutes to get it to us.
Well,
okay.
First thing, this all started with a letter by the Fords to the County Commission on February 4th. In that letter, they requested 3 things. 1, a change in the SWC, the SWR, and those 2 have been handled quite readily. But twice in that letter, they asked that to be done in consultation with the nearby property owners. That part has never occurred. Nowhere at any time did anybody involve them. When I called to get information on it, I left 2 messages, couldn't get a return. When I finally got through, I got a lecture on what the SWAC was and that there's nothing to see here. So what I'd like to tell you is, first on the SWC, there is a separate zoning already for distribution centers. And how you add one zoning to another zoning where we have 2 separate zonings for the one doesn't seem to make sense. And I apologize.
You're fine. You're
This
fine.
whole thing's got me a little upset.
Yeah.
So the original SWAC, when it was developed, was set to be we were building a little Heathrow over there. And it included Deltona, it included Orange City, it included Volusia County, it included DeLand. All the other cities have pulled out of it, and we're left with this mess. And there is, if you go to, I think it was page 5, the actual definition of what the SWC is supposed to be.
To facilitate a mixed
Yeah, on
use.
page 5,
multi-purpose,
and you go to the actual classification of what it was for, and you go to line 5, and it was supposed to be a corporate and general professional office space, research facilities, light manufacturing, flex office warehouse space, and retail use for hotel or bars or things of that nature. And then a vertically mixed residential uses. And the way it was sold to us back in the 90s was that that was going to be a little Heathrow over there. Now what we're getting is the DeLand Airport Industrial Park and the Orange City number streets all thrown in there. And it's a little different thing. We would have thought about the 7,500 square feet back then if we had known that we weren't going to get a nice development there. We were going to be getting what they're trying to give us. When you look at the 7,500 versus 50,000, first I want to note, if you step off my property, you're stepping onto that property. I am required to have 218,000 square feet for my residence. Now you want to go across the fence line and you only have to have 5,000. That's a 40 times reduction in the land requirements. We are in a URL. You're butting it up against a URL. All of the homes there are 5 acre, or at minimum, if we beg and plead with the county, we can get them to split it in 2.5 acres, in which case we only have to have like 115,000. Getting from the 7,500 to 5,000, I would agree with Mr. Feller, is just ridiculous. That is too small of a lot size to begin with. And the two other ways to change that problem, one is the width requirement from 75 feet to 72 feet. If you do the math, that allows you to put 7,500 on 1 acre with 4 houses.
Okay, hold on just a moment. You've exceeded the 3 minute, but is anybody getting in for information for Mr. Fowler that'd like to continue? Okay, I'm gonna give you another 3 minutes. Go ahead, sir.
And if you do that, that allows you to range it to where you can have 4 lots on there. You can have a 64-foot wide swath down the center of those 4 lots, which is wider than most spots on Interstate 4. It gives plenty of room for the roadway and for the utilities. And it just requires getting rid of the 75-foot width requirement and dropping that to 72. The other way is lowering the minimum requirement from 4 homes to 3. The other way is we look at just dissolving all of it because we're not doing any of the original plans, and just let them go back to requesting zoning for whatever it is they want to try and build there. We keep patching a hole that is there, and it gets worse and worse and worse every time we patch it. And the SWR and the SWC have just fallen apart. They're not what we originally set out to build there. It's a completely different thing now. And any other property owner that wanted to do this with this property would have had to come here to request a zoning change. In this particular property, they go to the county council and get the county council to come to you guys and put a stamp on it and then send it back to them so they can feel good about it. And I don't understand. It apparently is important to Frank that the property owners surrounding it are involved. Twice in that letter he mentions that he wants the county to get with us. And so I would actually heed that message and listen to his own words. And when he's asking you guys to please pay attention to the people that live around there. And just, it just seems like this whole process for the SWR, the SWC, the SWAC has fallen apart. It's nothing of what it was, and we really just need to look at just letting Frank do what he needs to do over there and come here and request zoning changes to fit whatever that is, where we can all come in and discuss it and have an opportunity and weigh it up against a URL that's right next door to it and the property that's there. And I apologize, but that's pretty much everything I had to say. And I hope that you all would take that into account. This all came kind of quick, so a lot of my neighbors couldn't get here. They have to work at this time of day. But it's just really, to put 5,000 square foot lots right up against my fence and then requiring me to have 5 acres to build a house. I don't see where that falls into any type of planning or zoning. It's, in my opinion, ridiculous.
May I, Chair?
Feller, go ahead.
I'd just like you to know that I did reach out to the Victoria Gardens HOA president as well, too, and I think we got a letter. I don't know if it was from her on her behalf. And she stressed that a lot of the Victoria Gardens residents would not be, Victoria, I shouldn't say Victoria Gardens, but park all around. And that's what kind of brought up that same sentiment. So I do want you to know that from my perspective, I reached out to find out what one. I know that the county may be different, but I'm definitely trying to do that.
Well, and one last point, in where we live, and some of my other neighbors are here, it's very secluded. If I call 911, it's a 35-minute to 45-minute response time because they can't find us. And 5,000-foot lot squares bring crime. And I'm sorry, I don't mean to say it about that way, but you go look at the number of streets down in Orange City and the police calls, they go there versus everywhere else. And it just, our protection has been seclusion. And that is we know that's going away. But to bring that to us is not only dangerous, it just doesn't meet any logical sense.
Can I have a question? Just one simple question. So your property abuts this particular site?
My fence line is Frank's fence line. We share a fence line.
You guys share the fence line. So let me ask you this question. Would you prefer 5,000 square foot lot homes in your backyard, or would you prefer hotels in your backyard?
Well, I'm going to tell you, the first thing is my front yard.
Okay. All right, your front yard.
Just because we've had clarity problems with that today. And the way the SWAC was initially developed with the hotels, this residential area is a line around the outline of the property to buffer between the industrial area or the commercial area and the housing area back there. And so to answer your question, that was the initial thing to begin with, that you would have this protection, this area that would kind of guide between us and the beginning of the commercial.
A buffer of homes between that and the commercial.
Correct.
And it's actually there. It is actually there. If you saw the county council one, the buffer does go along all the sides that don't abut the roads. So the commercial is on the roadways, and then the residential is up to the north, to the west side of all of it. So there would be residential against residential, and then commercial on the roads. So there would be no opportunity for a hotel there. It can only be residential.
And I think the side you're talking about that you talked to, I think they're mainly an acre or more on that side. On my side, it's all 5-acre lots. And that's going to not just come in front of us, but for Julius, it's going to actually go down the whole side of his property also. So he's going to be surrounded 330 feet on the front and 660 feet down the backside with 5,000 square foot homes.
Okay, sir. All right. Thank you for your participation this
Thank you.
afternoon. Mr. Watts. Good afternoon, sir.
Good afternoon, Mr. Chairman, members of the council. For the record, Mark Watts with the law firm of Cobb Cole, 231 North Woodland Boulevard, DeLand, and appreciate the opportunity to be here with you this, afternoon now. I was, number one, coming to speak in support of the change, and I wanted to give you a little bit of context, and actually it's been kind of an ironic week with regard to the SWAC, the Southwest Activity Center, and the various cities in the county that have been part of it. This is actually the third hearing that I've had this week on pieces of property that are still included within the Southwest Activity Center and have development moving forward that's consistent with that long long-term plan. So I'll give you the same example from a timing standpoint that I've used at the other hearings. The Southwest Activity Center, later this year, I've got my 30th high school reunion here in DeLand. The Southwest Activity Center was originally adopted in 1992, same year that I graduated from high school. So it's been around for a long time. And I think the letter that you see with regard to that came in from the Ford family really focuses on the fact that both the Fords and a number of the larger property owners that have had property around, the 472 interchange have worked with the cities and the county for about 30 years, a little bit longer. I was talking to Pat Northey at a hearing last night, and she said that was one of the first things that she did when she ran for county council. Was one of the reasons she wanted to run was to encourage the SWAC and the development of that area for Deltona. So we approved some of it last night in Deltona. Monday night we approved a 150-acre non-residential development at the intersection of MLK and 472 in the city of DeLand, which is their large piece of the SWAC, for about 2 million square feet of office, hotel, warehouse, light industrial uses that got approved by the City Commission of DeLand Monday night on first reading. So we're finally starting to see a lot of the plans that have been in place for a long time move forward. So let me bring you to the specific requests that are here now. The policies with regard to density and the policies with regard to use are already in place. Your comprehensive plan says you must do these things to develop your land in this area. Included in the policies are, we have the distribution center use that's listed there. You saw one of the glitches here is that it's in the comprehensive plan, but it wasn't included in the zoning. That's in the SWC change that's in front of you. With regard to the SWR changes, when the DRI went away, and the DRI, keep in mind, the comprehensive plan policies were there prior to the DRI. We've had the activity center in place prior to the DRI going into place. The DRI came into place in the early to mid 2000s. So the DRI or the comp plan had already been there for about 10 years before the DRI came along. When the DRI, from a state level, DRIs no longer exist. And so that was one of the reasons why you saw the cities and the county terminate the DRIs, because DCA got rid of the DRI process because the legislature got rid of the DRI process. And so that's why you've seen those changes. And if I could beg for just another minute or two.
Yes, I'm going to go ahead and extend the same courtesy to you and give you another 3 minutes.
Thank you. I appreciate that. So the DRI, DRIs went away because they went away from a state level standpoint. So what the staff did is take a lot of the standards that were in place and move them into a zoning classification that covered the county portions of the SWAC that previously were covered by the DRI. What we've discovered, and I'm working with Pulte Homes, they're working with the Ford family on some of the residential areas north of 472 adjacent to DeLand, but within the county's jurisdiction. What we've discovered is we cannot legally comply with the comprehensive plan because we can't design a subdivision. We actually even looked at using your cluster standard, but even using the cluster standards that exist in the county code that lets you go down to 5,000 square foot lots with the existing zoning in place, you still can't get there because of the additional open space that's then required. You literally can't get to that minimum 4-unit density that's required by your comprehensive plan. So right now what you have is a legal requirement that prohibits a landowner from developing their property at anything less than 4 units an acre, and a zoning code that is inconsistent with that because it doesn't let you get there. And so we've worked with staff over about a year now to look at how you can adjust those standards to make it fit. And the reduction of the single family lot size down to 5,000 square feet is what gets you there. I'm here to ask you to consider 2 other things there just to prevent there from being future issues. Like the variances that you mentioned, Mr. Feller, a little bit ago. With a 5,000 square foot, the staff change in front of you includes the reduction of the lot size to 5,000 square feet, but it doesn't adjust the corresponding dimensional criteria. And so if you look at your R5 standard in the county, which R5 is another county zoning classification that allows for 5,000 square foot lot minimums, it also has smaller setback requirements. And so as you have a smaller lot, you really should, to avoid the setback issues, reduce those correspondingly. So what the R5 standard in the county has is 5-foot setback requirements on 5,000 square foot lots. And so we'd ask you to consider adding that change to this as well so that it's consistent, you avoid having that issue. And the last thing I'd suggest is the SWR classification also allows townhomes. So you've got both townhome lots and these urban lots that we're looking to kind of put in and around this area that we've planned for a long time to have higher intensity. Consider recommending going up a little bit on the lot coverage for the lots as well, because you do have smaller lots. You do have a lot of people that are preferring single-story structures because of aging populations and things of that nature. Your standards in the county are at 35% on your lot coverage. What we've seen, for example, the city of DeLand approved a 40 and 50-foot lot subdivision just across the street. We had 5-foot lot setbacks. We went to, I think, 60 to 65% on the lot coverage as well. So just to avoid those problems and really kind of fix all the issues at once, I'd encourage you to look at those 2 changes as well. But I'm happy to answer any questions about the history of this because I've been around for most of it at this point.
Any questions for Mr. Watt?
Not so much a question as it is, I understand the 5-foot setbacks on the 50 by 100, but if you've heard even just 2 of them today were to go to 1 foot, because they want to build an elevator, or they want to do whatever. Sure. So I guess what I'm saying is I don't see it being feasible to continue to build houses at the way people want to build houses when then they want to add on, and it just keeps exacerbating a problem is what I see, and then we just have no setbacks. I mean, at that point, these people are building right to the lot line, basically through variances that come through. So I know that the setbacks are very small on R5 and they're 5 foot, but I still don't think that that resolves the problem from that side. I will say that, as I look at it and I hear, how it's done, I guess my only clarification would be every property owner has an opportunity to come here and apply for variances or zoning changes or anything like that if they wanted to increase density or change zoning or anything like that, right, without us necessarily approving this. Like what you're talking about without approving this change, right? Without doing this, so a property owner could come forward still and say, I still want to build a townhouse or a multifamily or whatever it might be, and go for it.
Absolutely. And so I think the way the county has chosen to approach this area versus the way that the city of Deltona or the city of DeLand has chosen to approve it. So in DeLand and Deltona, we're required to do a PUD to activate the zoning on the property within the SWAC, right? So when you come in to actually develop, there is no, when we approved that project in DeLand on Monday night, that project had county R4 zoning on it. The zoning had never been changed, but there was Southwest Activity Center land use in place. But the city of DeLand's comprehensive plan said if you're going to develop under the SWAC, you have to approve it through a PUD. For everything within that SWAC, the county chose not to do that. The county chose to say, we've worked with landowners for 30 years, 40 years. We want there to be certainty that doesn't require them to go through a zoning. It was a conscious decision not to require a PUD when the county approved the SWC and the SWR standards. And what wasn't realized at the time was that the standards that were adopted in SWR, which has been a particular issue we've been working with, don't let you meet the comprehensive plan densities. So it's a pretty simple issue, right, that we're seeking to fix, but it was an intentional decision from the county council's standpoint. The policy decision that's already been made was not to require PUDs, not to require rezoning, but to have a zoning classification that specifically allowed you to move forward just with plat and just with site plan.
But would it be fair to say that that was decided when they were talking with all the other cities and municipalities to make it so? No?
No, it was when the DRI was abolished and we adopted the SWC and the SWR. Okay. So the choice was made at the county council level not to require the PUDs the way that the other cities did.
Okay.
So, and that's the policy decision that's already in place that we're dealing with.
Mr. Costa, you had a comment?
Yeah, you keep referring to we.
We.
Who's we?
So we are, we as a community, number one, because this is, having grown up here and been here for as long as I have, I know that this area, we've worked on it in the context of the SWC or the Southwest Activity Center before the DRI was in place. Our firm has worked with the Kirk family, the Ford family, various other folks that were involved in the DRI being created back in the early 2000s. Right now, my client is Pulte Homes. They're under contract to.
That's where I was trying to get to.
They're under contract to acquire a portion of the property north of 472 on the south side of the Victoria Park development. And actually, to the road question that was raised, the property that they're looking to develop is going to be at the intersection of the extension of Casadega Road and the extension of Blue Lake Road, both of which will be constructed as part of the development here. So, the question about are we looking forward to the roads and the development of the road network here? Casadega Road is being extended. So there's a signal going in right now today. The poles are up yesterday when I drove by there. There's a new signal at Casadega Road and MLK. That road is going to then continue across south of where the apartments are, the Integra apartments are. It'll intersect with Blue Lake, which is being extended from Orange Camp all the way down to 472 to provide more of a grid network so you have more opportunities for traffic to go in different directions. At the same time, we just established Kirk Road. That was part of the zoning on Monday night, which, if you remember, the old plan for the frontage road along I-4 is going to come from from what's the road by Daytona State College? Summit to Orange Camp to 472 to Graves to Saxon. That was the old route that was approved. The first section of it is actually going to be built as part of the DeLand Tech Park. It's called Kirk Road, and it'll create a new north-south connection between 472 and Casadega Road. So that's going in place, in addition to some more roads that'll be in that section as well. And then I know the county is working on trying to finally move forward with the realignment of the VMP and MLK connection. I think they've had some significant headway on that as this is happening. So it's hard to see sometimes, but the work towards the roads is continuing, and none of these decisions on zoning exempt you from the concurrency process. You still have to go through the process for testing whether the road capacity is there when the development is forward, and that's a site plan and plat. So we think the change makes sense given the current policies that are in place from the county council standpoint. This is the thing that lets people move forward with the development of their property.
Thank you, Mr. Watt. Okay, I do have another public participation form, Mr. Wren.
Good afternoon. My name is Chris Wren. I'm with Pulte Home Company. I had submitted a second speaker card in case Mr. Watts needed, but you awarded that to him, so he's good. Thank you very much.
Thank you. Okay. We don't have any other public participation forms. Would anybody like to speak to this case ordinance? Yes, ma'am. You can speak, state your name and address, and then once you're done, if you'll fill out a participation form and hand it to Ms. Ray to my left. After you've spoken, go ahead and speak. Your name and address for the record.
Hi, my name is Yoko Moquette, and I'm at 1512 East Wisconsin Avenue, right next to Mr. Tom. You guys, this is the first time I come here, and I see you guys so proud about, what you do and how you protect the county, the trees, and all of that stuff. And I know this is not what you want to hear, but you should see Mr. Ford's property. I'm sorry, I'm a little bit nervous. Mr. Ford's property is beautiful. Trees everywhere, heaven. And I know things have to be done, but I think if they're done into such a clump, that's all going to disappear. I think if we keep it the way they are, if he tries to build larger homes, maybe those trees will have a chance. Maybe the birds, and the area will have a chance. I think it'll make it a lot nicer, more sheep, more for people to want money to come in. You don't want to just clump a whole bunch of homes together. I'm sorry. Thank you for your time.
You're fine. Thank you. Okay, do we have anyone else that'd like to speak? If I could get you to fill out a form and give it to Ms. Ray. Good afternoon, sir. Could I get your name and address for the record?
Julius, last name Francis. I live at 1520 East Wisconsin. I'm Tom and my other dear sister and neighbor. So, brother with the deep pockets, you can come on over now and shell out those funds. I'm ready for it. What I want you all to do is to think about what I'm going to have to deal with if, in fact, this passes, because there are two roads that abut my property and Mr. Ford's property, and so it will be a nightmare once it's done. So what I would like for you all to do is to think about you living in that house that I'm living in now. And I want you to think about what you would want done if you would have to walk out that house that we live in now into this nightmare that's on the way. So anyway, like she said, the trees are there, bears visit, you name it, coyotes. We have that slice of heaven that you all are talking about. And we don't want to lose it. I don't want my grandkids to lose it. And I don't want my neighbors to lose it. Riding through the neighborhood now is, when a storm comes, we don't call it the city, we are the city. We all come together and we work and we clean the roads and we complain about things in a united manner. I got a call last night about this meeting. That's why I'm here. And when last time I talked to Tom, the attorney Ford, he didn't mention anything about selling the property or doing something different. So I slept well until I got that call last night. So sleeping won't be quite as easy anymore. So think about it, ladies and gentlemen. What would you do if you live where I live now?
Yes, you can.
All right. What intersection were you talking about? You said you're at an intersection of two roads.
Well, yeah, the land is in my front yard and one of my side yards. But I'm the last house in that.
The names of the intersection.
Yeah, so I really have been hidden for a long time. We don't even get trick-or-treaters, so you can imagine. Okay. I'm at the very end.
Okay.
Yeah.
Thank
Mr. Bender?
You might want to have him fill out a card
Yeah.
going in the opposite direction.
Yes, sir. I need to get you to fill out a form. Right over there, there's a form. If you'll fill that out with your name and everything and give it to Miss Ray on my extreme left. Anyone else would like to speak to this? Okay, we're going to close the floor for public participation, open it for commission discussion. And I'd like to start out by saying, no matter where I go, no matter who I talk to, this is a main topic, the high densities that we've experienced in this area, and I actually have to live in this area. And my personal opinion set aside, I can't ignore the fact of the residents in this community that are being affected by the high densities that we're experiencing. SWAC was put in place back in the 90s. That was way before we've experienced any of the densities that we've experienced just in the last few years, to be honest with you. So now, all of a sudden, we put in all the PUDs everywhere. The cities have, not so much the county, but a lot of the cities have. And we put in these PUDs, and now there's nowhere else to go, so we're going to go to what was originally to be the high-density area to begin with. And in saying that, maybe we should be looking at the comprehensive plan. Maybe we should have that reopened, looked at, and see what the residents want for their area where they live. Because to sit here and to continuously add more density, and that's pretty much what we're doing, because the zoning keeps it from being a higher density, I should say. And so, because it can't meet the minimum density requirement. So, I don't know if this was all thought of back in the 90s when this was put into place, but at least it ought to be looked at. It ought to be looked at by all the residents that are definitely affected by this, and I hear it every single day. And like I say, it's not a personal opinion. I hear it from everyone. So I just believe we need to sit back. I know there was an NRAC committee supposed to be put together. Maybe they should address this. Maybe they should address our comprehensive plan. Maybe they should look at how it affects the constituents of this county. So, and the residents, and because no matter where I go, I hear it. So that's my opinion on it. Go ahead, Mr. Feller.
Thank you. I tend to agree with you, Chair, and again, looking back on this, I feel we as a board are put in a weird position because we're kind of doing the dirty work that the county council didn't want to do last time, and they basically said, oh, well, you know, this is how we're going to do it. But I think we're left with two options, as legal said, where we keep things the same, or we make these changes. We go with these recommended changes. From the PLDRC level, I'd be more than happy to hear PUD applications and all that stuff, because then we can generate these things in a smaller way and not look at this as just making this a sweeping change. I understand the difference in adding the warehouse. I mean, I get it. I feel like when this was written up, and I don't know exactly the time that this ordinance went in, but I thought they took into account flex and warehouse facilities. I think distribution centers are a little bit newer, especially in this area. So I'm kind of at the same point as you are. I hear this, and nobody, I've been reached out to by a lot of people, and I reached out myself to investigate this. And I feel like these landowners are not being deprived. They can still come to us. They can still ask for PUDs on this stuff. But I am not comfortable sending a recommendation to make these changes.
Anyone else?
Yeah, I'd like to say something. I was on this board back when the major part of this came across, and I'm with Mr. Fowler. We were presented this was going to be a layout of Heathrow on a larger scale, but not with all these little tiny houses all stacked up, and a lot has changed. And what stopped that in its tracks was the 2008 housing crash. Everything totally stopped. And me being in real estate, housing market's crashing again right now. But it just wasn't what was presented to us back then. And a lot's changed. So I think we need to, I'm with y'all, we need to reevaluate all this. My opinion.
Mr. Bender?
Same boat. I think that it's inevitable that this area is going to develop. I've always known that, but I don't see this being smartest way to do it by just kind of giving it a blanket and letting it go. So I'm not having a problem with the adding the words about the warehousing and things of that sort, but it's the smaller, the heavy density residential areas that I'm concerned. So I'll have trouble supporting sending this to the county council with.
Mr. Feller?
Can I just add one thing onto that? I'm as equally as concerned about both, because I think adding this language will allow for the combination of what was supposed to be retail and all of that stuff to potentially be all clumped into one as one big warehousing or distribution facility, rather than the smaller job generating companies that, that we would like to see. And I think, whether it be a coffee house or a small shop or whatever, versus a $14 an hour distribution job, warehouse job or something. So I would say that I understand what you're saying, but I would still be against adding the language.
Any other discussion? Nothing else? Michelle?
And it's just a comment, really, in listening to all this and the different discussions is, and the talk about PUDs and how the cities have gone into PUDs and pulled themselves out of this and started doing that. And I served on the Planning Commission in Daytona Beach for several years. And one of the issues we consistently had as a commission was what we consider, or the Planning Council, was what many of the members considered as PUD spot zoning. And that people would, and I'm not speaking pro against, I'm just saying, we say, well, let them come in with the PUDs, and I'm not saying not to do that, but it's interesting the take from in Daytona Beach, where the PUDs were seen basically as a way to go around issues, put in quote unquote what we considered spot zoning, as opposed to an overall plan. And I haven't gone through this plan, so I'm not making a comment about that. But I think as we throw out things and say, well, let's just do the PUDs or let's just do this, that perhaps there are broader issues with that as well. That's just
Well, I'd like to say I'm not against development. I'm not against it at all. What I'm looking at is the densities. This is what I hear most of all the time. It's not that they're building a subdivision and putting houses on reasonable sized lots. It's when you get these higher densities and then we don't have the infrastructure to support it. And here we're talking about putting in new roads so we can get higher densities. It just doesn't make sense. We need to really sit down and look at our comprehensive plan and see what it needs to go in Volusia County and how we need to do it. And we can't be, well, we're going to do this and then the cities are going to do something else. We all need to get together on the same page. I don't know who they're listening to, but I know who I'm listening to on a daily basis. And it's not the same people over and over. It's different people no matter where you go. That's the same thing. You got two groups of people, one complaining about it, one cashing out and moving to another state. I hear it all the time. And I happen to grow up here, and I hate to see the road, the path that we're taking, simply for commerce, let's put it that way.
I do have a question to legal at this point, or to staff. So are our options either to forward this with the recommendation of approval or forward it with the recommendation of denial? Are those our only two options?
Yes, you can also continue it, because right now it's advertised as these two changes. So, Mr. Watts, recommended some additional changes. Not currently within your jurisdiction, we didn't advertise for it. So right now, essentially, yes, the two options are, you can recommend approval with comments, you can recommend denial with comments. If you'd like to make additional changes, we would have to re-advertise it for this, for another round. If you want to go beyond the scope of these two things, which is adding those uses and adding and lowering the minimum lot size in the SWR.
And would that be the only reason to continue it? Would be to do more stuff or to add more stuff into it? Or, I mean, when you were saying continue, I don't know.
Yeah,
would we continue it for more public participation? I mean,
Well, this is the public participation. To make this change, it actually requires 2 hearings before council, because you are adding uses to a zoning district. So if there are no other things you would like to consider in terms of the zoning, then your choices are, recommend approval, recommend denial. But we will carry forward any comments that you make. This is a legislative policy decision. It's not quasi-judicial. So you are determining what is the best policy for this zoning district.
So with that in mind, I'd be happy to make a motion with those comments.
Go ahead, Mr. Feller.
So my recommendation would be that we forward ordinance 22-135 to the county council with a recommendation of denial based on denying those 2 changes, based on the public commentary that we've heard here.
If you would
clarify them.
Well, yeah, if you would like additional comment, which you can, you're in your legislative capacity, you can continue it to another day, or another meeting. You don't have to make a recommendation. You are within your discretion to.
When you say, I'm sorry, I got confused on that. Continue it so that we could talk about it some more?
Yeah, or to invite additional public comment, or.
But the public will have will be able to comment at the county council hearing, yes. And they'll hear that our recommendation, or if it passes, the recommendation would be for denial.
Yes.
Okay, so I don't necessarily think that 7 of us need to continue it. I would keep my motion the same as forwarding it to county council with a recommendation of denial with the comments that we.
Okay, I've got a motion to forward 022-135 to county council with a recommendation of denial based on the comments that we presented here today, and then they can take it up from there. Well, I think we did our job. From Mr. Feller and the second for Mr. Sixma. Any discussion on the motion?
Yeah.
Go ahead, Mr. Costa.
We're throwing out the entire thing over one item. So personally, I don't have any issues with the distribution center comment or the warehouse comment. I'm on the fence with the single-family residential sizes. So we're basically throwing the whole thing out based on that. Now, Mr. Watts and his team may have some other avenue that might be satisfactory without us basically just kicking this thing down the curb, get down the street. So I don't know that setting it back with a recommendation of denial is accomplishing anything.
Well, in saying that, we had public comment here today about the original SWAC where it was supposed to be wasn't distribution centers, it was more of a small business type warehouse.
I understand that.
So unless you've got a different opinion on that,
Well, my opinion is that I have no idea what the SWAC looked like.
Yes.
There was no presentation that said, hey, here's what the original plan was.
Yes.
All we have is this to go by.
We do need more discussion within ourselves,
Yes.
because I will say, if you would like that, I did go back and watch the county council where the staff did the whole presentation. If you'd like to see that, then I would motion to continue it so that we can see that same presentation that was given to county council.
That opens up for additional public comment for those who couldn't make it here. It also opens up for the property owners as well to present their case as to what they're thinking on that perimeter. Again, I had no idea that the perimeter was surrounded by residential with all the commercial in the center. So without knowing that and only having 3 sheets of paper with no layout, I mean, the intersections don't mean anything to me without seeing them. I'm a visual guy. Show me a movie and I'll understand what you're saying. If you show me a book with nothing but print, we go nowhere. So,
well, I was basing on the public comments on what the intent was.
yeah, I don't have any. I would welcome additional input from both sides.
I concur with Mr. Costa, because I was going to be voting no on the motion that was.
And if I can clarify one thing, I'm absolutely 100% on my motion for the warehouse and distribution center. I'm not just saying, or I'm only looking at it. That's actually a concern that I've looked at, but it sounds like, I know I've done a lot of research on this one so far, and so I would rescind that motion if I'm allowed to, and open that up. Yeah, so I would rescind my motion for denial, sending it to county council, and I would continue this with maybe the objective of getting that same presentation that was shown at county council here.
Would this be continued for one meeting, 1 month?
Mr. Bender?
This is for everybody. I can see this as being a long, drawn out meeting. So, is it possible to have a separate meeting from the regular cases that we do, because that's all we do on that day? Can everybody give up and create another meeting for that? Because to try and incorporate that with another 20 cases, we're gonna be here that night. Y'all gonna feed us?
You can hold a special meeting of the PLDRC solely to discuss one topic. We'd have to advertise it separately, and we can work with your schedules to determine what an appropriate time and date is. It doesn't have to be the next scheduled meeting. If you just say we'll continue it to a time uncertain, we'll see if we can set up something that will accommodate everyone's schedule.
I think it's that important that I'm willing to give up the time in order to do that and give everybody all sides, because you probably have some people, board family that did this, initiated it, probably sitting back thinking it was going to be a rush, and going to the county council with the recommendation of approval, give them an opportunity to come in and present. Anybody else that's living out there that want to, say, man, I got to take a vacation day and come do this because it's that important to me. So that's kind of where I am with that.
I'm good with that. The only thing I requested is not be done in the month of November, because I'm going to Indonesia.
Oh, really? I thought you were talking about the election, which is a lot of what this has to do with.
Well, that too.
Can we do it after
No,
the
I'm
election?
getting away from all that.
Do I have to change my motion, or do I have to include
Just
a date
withdraw
at
it.
this point?
No,
Yeah,
just
I've
withdraw it.
already,
Stoney has to withdraw.
Make a motion to continue, then we're good.
so I withdrew. I already
Yeah,
withdrew.
and I withdraw my second
So
too.
that's withdrawn. So then, how do I make the motion?
You just make a motion to continue to a time uncertain, which could include a special meeting of the PLDRC.
Well, then I will make the motion in ordinance O22-135 to continue it to an unspecified date,
Which may include
which could include a
special meeting.
Right. Second.
I suggest a
Good.
special meeting because it's,
Yeah.
if everybody shows
Good
up that
idea,
needs to show up, it should be lengthy.
Can we put a timeline on this? Because the continuance could go
Yeah.
for a year without an unspecified date.
Within 3 months, 4 months, when's 3 months from now? That's actually November. 4 months before the end of the year?
I would say
Within
4
90
months.
days, can we do 90?
December? Sometime in December?
Sometime in December would,
If it's up to you. It's
that'll
up
be
to
my
the-
motion for sometime in December. A special meeting.
Well, do you want to wait till the new council seated in January? We can do
Well,
that.
Well,
If
this
we
is
have
the-
it in December, they're
this
gonna
is
hear it in
your
January.
this is your meeting. So if you
No.
have it in December, it's going to get forwarded to the new council.
That's my recommendation is December, if anybody wants.
Well, the new council might have input, so would you rather do it in January?
Well, what I was saying is if we hear it in December, it'll go to the new, but I guess we could do it in January if that's the case.
It's up to you.
What day are they? Yeah. January.
They get sworn in first Tuesday, January.
Yeah. So I'm
Something.
good with December or January.
Because we're going to get some input from, and it may not be any different than what they've sent us already, you know, but they may want to look at this and go a different direction. We don't know, you know. We can get an update,
Well, and currently our staff's, orders are, workshop this thing, get, as much public comment as possible, get the PLDRC recommendation. Until that changes, we're going to proceed forward. So right now we're in the PLDRC provisions and it's within, it's in your court. You can do with it what you want. You can delay it until January, you can hear it in December, you can hear it in September or October for additional comment.
I will specify that my comes with January, if somebody wants.
Okay. I'd rather do September, October.
If it pleases the board, if you can give the staff an opportunity to coordinate with you all, if you can set it to not set a date, then we can coordinate with everybody, because if you're
Yeah, I'm
looking
not,
at
okay, we
December,
won't set a date.
we have room issues.
Just not November, that's all. Okay.
Let us work to find
That'd be
dates
great.
that work for everybody, and then we can get back to you and set that date.
Okay, thank you. Okay,
Do I need to modify the motion
do we
again?
need a motion for the continuance?
No, I think we well, you do need a
understand my
motion to continue, but we understand we're going to try to set a good meeting
Earliest
sometime.
convenience.
What Paolo said.
Can we add not to exceed 6 months? Can we put a timeline under it? I'm seeing this could go
Yeah.
an eternity.
Yeah.
Yeah,
And I
Fine with
think
that.
whether
Within
it's
6
election or
months.
non-election, it doesn't
Right.
concern me one way or the other as far as this board, this body is concerned. I just want to get this heard from both sides and get the education and find out exactly where it's going and how it's going. What the council does is a completely separate issue. I don't want to see this going forever. So we can put at least a 6-month timeline, anytime within 6 months.
Yep.
Is that enough, Trish, to work something out?
Yes, sir.
Thank
Perfect.
I need a motion.
I did, my motion is that with,
Continue and to be
Continue,
brought
yeah.
back at a special meeting within 6 months.
Second.
Okay, I got a motion continues for continuance for case number 022-135 to a time uncertain as long as it's done within 6 months. From Mr. Feller and a second from Mr. Sixma. Any discussion on the motion? All those in favor signify by saying aye.
Aye.
Any opposed? Motion carries unanimously. Okay, that does it for the new business. We've got one old business case, so
Hey, guys, thanks for coming out and waiting so long, too.
okay, Ms. Shelley, can I get the old business?
Yes, sir. Case number V-22-098, variances to separate non-conforming lots, minimum yard requirements, and maximum lot coverage. Urban, single-family, residential, R4 zoned property.
Okay, thank you, Ms. Shelley, and this is Ms. Smith also.
This case involves an approximate 7,000 square foot lot in Ormond by the Sea. The applicant is seeking to separate non-conforming lots so that she can get a permit for an addition onto the rear of her house. So there are 3 variances. The first is to separate from a lot that it was previously attached to. The second is to reduce the rear yard from 20 feet to 14.99 feet. And then that would in turn increase the lot coverage from 35 to 36%. We looked at this and we feel that this variance is a reasonable variance for this location, and we would recommend approval.
Thank you, Ms. Smith.
Oh, I apologize, I forgot. We did get one letter of opposition from the neighbor behind this parcel, so in the rear.
I think I got a public participation form from. Okay, any questions for staff?
I apologize, I have to correct one.
Yeah.
This was not my case. This was a former planner's case. The recommendation is to approve the separation. It was to deny the variance 2 and 3 because it could not meet all 5 of the criteria. It's late in the day, I apologize.
Thank you, Ms. Smith. Any questions for staff? Is the applicant present? Good afternoon.
Good afternoon.
You've been
Do I need to
sitting
get
there all
any
morning?
Snickers today because everybody seems a little on edge. It's lunchtime. My name's Sherry Papanicholas. This is my husband, John Papanicholas. We currently reside at 7785 Crescent Run Court in the Plata, Maryland. We are in reference to our future home within the next few years of 29 Silk Oaks Drive, Ormond by the Sea. What we are requesting here, we purchased our home 5 years ago. It's a 2-bedroom, 2-bath. Love my neighborhood. Love my beachside home. Love the state of Florida. Volusia County is amazing. What we're requesting is to add on an additional room, bathroom with a closet. We thought about going up in the reference of building onto this lot, but it didn't fit the aesthetics of the neighborhood because they're all pretty much single-level homes. We didn't want it to be, you know, very ugly to the eyes, I guess you should say. We wanted it to be very aesthetic to the neighborhood. Of course, we always do have the option of going up, I guess. It will not be seen from the road. If you've driven by my house is a small rambler. It's going to go right off the back. It's going to infringe about 15 feet. I'm sorry, about 5 feet into that 20-foot buffer that they have in the back. Reason being, we have 2 very nice size bedrooms in our home. Don't really want to put a rinky-dink other bedroom in there because it just doesn't fit the layout of the home. It's not, the one thing that I want to say, we've looked around at the sky view of the neighborhood. There's a brand new development 3 streets up. Some of them houses are way closer than 20 feet to their property lines in the backyard. A lot of my neighbors have pools, and I know pools are a little different, but they're pretty much right up against those back property lines. I'm not doing that. All I want to do is put a nice sized bedroom. We have a growing family. 2 years we hope to be down here. There's grandchildren coming. We just want something that fits the scheme of the neighborhood. It does not affect any environmental around our house. We're not tearing down trees. We're not killing turtles, ants, whatever's in our backyard. It's going to be very simple and plain, and all we ask is that you take that into consideration.
Okay, any questions for the applicant? Okay, let's see if we've got any public participation. We do. We do have one here. Okay, Miss Denise Konopka? Konopka, okay. I've did worse. I've did worse to people's names, believe me.
Thank you. I appreciate your hearing us. So we live behind the applicant.
Mm-hmm.
We bought our house about 3 years ago.
Okay, I need to get your name and address for the record.
I'm sorry.
I'm sorry.
Denise Konopka, 32 Sunset Boulevard
Okay.
in Ormond Beach. This is my husband, Robert.
Thank you.
So we
I
bought our
didn't
house about 3 years ago, and, you know, we bought it with the existing buffer zones in place, and we do like our privacy. We basically have two reasons for objecting. Number one is the privacy factor, that their house coming back toward our house by another 5 feet. I picture the block structure, the roof line, what we could see from over our fence, and it just doesn't make us real comfortable. There are zoning laws in place, and we would hope that, you know, unless there's an extenuating circumstance, that they be adhered to. The other reason that we have for objecting is that we've spoken to a couple of people in the real estate business, one of whom has sold real estate in Ormond Beach for about 30 years. She's very familiar with Beachside. The houses, as you know, are very close together. And she said that if we were to sell our house, and let's say there are 3 houses that a family's looking at, 2 others and ours, and the other houses had the buffer zones in place, they would look at those homes and then come to ours and see that our buffer zone, that house behind us is closer than the other houses would have. And they might be uncomfortable with that. They might feel that the backyard is a bit cramped, and they might decide in favor of another house. So it just is a reason for someone to not be interested in our house. And we feel like when we bought the house, we knew we were buying a 2-bedroom, 2-bath house. We knew what the buffer zones were. We knew that if we wanted to add a 3rd bedroom, we would have difficulty with it. I mean, we would like to have a larger house too. But we know that if we want a larger house, we should look in another area and buy a 3-bedroom home, which in fact we have done a little bit of looking. So I understand the need for a larger house. We have children and grandchildren who come to see us too. We put up the boys in the dining room with sleeping bags, and I know as they get older that won't be something that we can do for them, but we just feel if there are laws in place, they should be adhered to. And we're asking for you to help us in that regard.
Okay. Any questions for the applicant? Mr.
Yes.
Young?
Could we bring up page 14 on the map, on the picture, the aerial picture? Okay, no, 14, page 14. Okay, which house is yours? Let me see. Let's, the one with the arrow on it? Right there? That's your house? That's their house? Is that your house with the one with the arrow on it?
I think so. I can't see that.
Okay.
It's inverted as far as I'm.
Okay, because I see the one next to that, to the right of that, is right up against the lot line.
Mhm.
You see, the one next to you apparently is right up against the lot line.
Right, that's a pool enclosure.
Yeah, yeah, that's right up against the lot line.
That doesn't impact us.
Yeah.
That's on the side of us.
No. But if they add to the back, okay, that's what I'm trying to say, because I've been in that neighborhood quite a bit. In fact, I'm very familiar with that neighborhood. So, have a neighbor, a friend that's right there. So they're going to add some to the thing. But you're set back pretty well. And you've got another house that's right in front of you that's next to them to the left, that's very close to the lot line even.
That's you're referring to. I can't.
That was there when we moved in.
Yeah, that's what I'm saying. That's not uncommon in that neighborhood. I mean, I see some of them that are very close, so I can't see a problem with it, considering the neighborhood. It's atypical to all the houses in that neighborhood. So I'm just trying to figure out where. Thank you.
Yeah, I guess I would ask why they have zoning laws if they're not adhered to.
Well, yeah.
Like every variance today has been approved, except for that last one. So why have laws?
Well, I've asked myself that too, to be
Sure.
honest with you. But unfortunately, it's happening.
That's why we have a variance.
That's why we have the variance, but I mean, it's creeping in.
Yes. We have to look at these situations and see what's reasonable and what's not reasonable.
I mean, but unfortunately, it's happening all over, and you know.
But the house right beside the one that they're speaking of, it extends closer to the property line with that right on the opposite side of your home.
There's some that you can't even walk almost between the fence and
If
the
I
house
may,
along there.
If I have a question.
And what you got to take into consideration too, they could always go up.
Right.
I understand.
And then it'd be more or less of a privacy if they go up than back towards.
Thought about that. We just
Yeah.
want to adhere to the law.
Yeah, okay.
Eh,
Well,
yeah.
thank you for your participation.
I have a question.
Oh. Go ahead, Mr. Costa.
Is there a fence in the backyard?
Yes.
Yes.
6-foot privacy fence?
Yes.
And how much of their house can you see now over that 6-foot privacy fence?
Half their window.
Half their window and up?
Pick
Okay.
up into their bed.
All right, thank you.
So-
Okay, I appreciate you coming in and
All
making
right,
comment.
thank you.
Thank you.
Thank you.
Okay, yes, you can have a chance to rebuttal if you'd like.
There is a 6-foot privacy fence in the back. As with all those houses, we can all
Right.
see half a window and up. You guys have been there. We know what they're like. I really, I'm not only going, it'll be 15 foot from the line. Like I said, a lot of those houses around there, I could put a pool right up against my property line. That makes no, when that would be louder than my house. Did you have a question? I'm sorry.
Yeah, okay, let me ask another question, just to satisfy my own, for my own edification. Looking at this picture here, are you gonna, this room in are you gonna add to the right or the left side of it?
If you're looking at that, it's to the left.
To the left, so you're gonna be moving right into where that arrow is right there. So
Exactly.
you are gonna be a little bit closer to them. How far are you gonna extend out past what, the structure that's there now?
Through that structure, it's only like 5 feet. It's not.
No, I
much.
don't mean that, I mean to the back of the yard. There's a,
You should have had a copy of the addition.
yeah, let me see, let me look at
I
that.
think it was 4 feet.
It's,
Thank
Because
you.
it seemed like that
No,
room was
I
12
mean-
feet, and they're going out 16.
we're still gonna be almost 15 feet off of the property line.
Yeah,
So we're not, our setback's 20, yes. So
I was thinking of it and compared to
The little
what's
porch?
the little porch.
the porch on the back, we're gonna be another 3 to 4 feet, I do.
Okay, another 3, that's what I was trying to get at, about 3 feet closer to the lot line than your porch.
Correct.
Okay, that's what I was trying to get at.
I got
Thank
it.
you.
Single story, we're not
Snickers.
going
Yeah,
up.
I
we're not
got
going-
that. I was just trying to see how much past the porch you were getting, only 3 feet. Okay, thank you.
Thought going up would be intrusive, I guess, maybe is the name I'm looking at. 'Cause then
Well,
I'm
there's,
looking
I don't
down
think I've seen any in that neighborhood that's got a second floor.
At the very end of Sun's,
Oh, yeah, the one down on the corner. Yeah, that's correct.
out of place.
But
That's
in the
James.
midst of, we had this meeting in July and it got postponed because they did
Didn't
not
get
get
a
a
letter.
letter, not from us, that we were not
It's
provided
okay.
their address. But anyways, I've got plenty aerial photos, and we've also had 7, if not 8 different neighbors offer to come today. I didn't feel like we needed their support, but so far, everybody has said, you shouldn't have a problem. I have aerial photos of all up and down Ormond by the Sea of many houses added on to, and are probably closer than 15 feet. There's some houses that are 6 and 7 feet from our property line, so I don't think that we are being unreasonable. I just feel that a 10-foot bedroom doesn't fit our needs if we're gonna put the cost of construction in. I just don't want a 10-foot bedroom. I'm just asking
Okay.
more space.
Does the R5 zoning, that's a 5-foot rear setback, correct? The R5?
No.
Or R9 maybe, it's R9 I think is a 5-foot. Well, I mean, I only know because I had an R9 property and it was 5 foot, so
The rear yard setback in the R5 zoning classification is 20 feet.
it's 20 feet.
The
in R5.
side yards are 5 feet.
About in, oh, R5, and theirs is R4, so it's the same in R4? Yep, and the only other thing I'd ask is if you could check R9, and I know this sounds silly, but there's all these different densities, but I was on an R9 property and thought I had a 5-foot set. And I'm just curious on it, more so, but I also, I mean, my big thing is, especially by the ocean, is that you're not covering the entire 100% of your property, and it goes to 36%.
There are some houses along there.
I get a little bit, I look at it and I'm like, oh my goodness, why are we at, I mean, maybe
See-
35% is too low for a county, but.
See,
yeah.
this one here, is almost covering the whole lot.
Did we know?
Okay. Let's
R4
move
and
on.
R9 are both 20 feet rear yard.
20 feet? Wow.
Okay.
Good, thank you.
Just as
All
a
right.
reminder to the board, this is the same area that we brought you an administrative rezoning a few years
Yeah.
ago to reduce the widths.
Yes. That's why I was asking, I'm sorry that I.
They unfortunately are a little further north, so they were not part of that. We were talking about doing
Right.
another phase.
That's what I thought too.
Okay, let's close the floor for public participation. Open it up for commission discussion or a motion.
I'll make a motion on this one. I make a motion that we approve V 22-098 with, and I don't think it has any conditions at all, staff recommended conditions. So I recommend we have, did it have one?
Yes,
Okay, I missed it. At this late date, at this time in the thing, with the one condition.
Second.
You had one condition?
Right, with the one condition.
Okay. Okay, I've got a motion to approve variances 1, 2, and 3 for variance 22-098 with the one staff recommendation. Any discussion from Mr. Young and a second from Ms. Shelley? Any discussion on the motion? Hearing none, all those in favor signify by saying aye.
Aye.
Any opposed? Motion carries unanimously. All right, folks, that got us through the day. Next is any other public items?
No, sir.
Okay. Any staff items?
Yes, sir, very quickly. Just to let you know, we have extended offers and we have confirmation that we will have 2 new planners on board. So you'll be seeing more people in the room next month. We're hiring internally, so we will be bringing in people with strengths from land development and from traffic. So I think you'll be very pleased on the
Okay,
road with
thank
our
you.
team.
Staff comments other than that?
No, sir.
Okay, commission comments.
Hey, I would like to say that this isn't really late. I know Stoney was with us before, but we used to have meetings where we'd even carry him over. They'd buy us dinner, or we'd carry him over to the next day.
Well, we like to keep moving.
Oh yeah, we had a couple of them that we had the station, because I've been here probably longer than I think even Stoney.
I do have a comment and a question.
Oh, okay.
As soon as he's done.
Oh, my only one was to say that I think that this is one heck of a board. I mean, you made some statements today, Mr. Costa, that absolutely got me thinking and got me prepared to look at some stuff. I just think that the knowledge is really, really important, and I'm glad that you stepped in on the continuance for that case, because I didn't know, looking at it, you don't know which way to go, and I appreciate the work that this board does, is all I'll say.
Question is more of a procedural question.
Yes, sir.
Going to the meeting prior to this one. Is there a limitation on time for the presenter?
No.
It's wide open.
Yes.
So they could stand there for an hour and a half, 2 hours, and just bloviate about nothing.
Well, it's up to me to keep them in the realm of.
Understand that, but there's no timeline where you can try to keep them in there, but technically they could just keep talking.
Yeah, I get it.
The chair has the authority, he's the presiding officer and has the authority to, if someone is not, we are in a quasi-judicial context, if someone is providing, nonsense.
Or repetitious material.
Yes. So here's the thing. I'm so glad you brought it up.
So am I.
I have been drafting quasi-judicial procedures for use in county council, for use by this commission, and for use for other quasi-judicial proceedings. It's usually used when you have to limit the time for the presenter to present, because either there's too many things on the agenda, it's a very controversial item, you want to provide equal time to everyone. Usually it's drafted so that it's up to the chair to determine it well in advance how much time a presenter is provided. My usual rule of thumb, if you have to talk more than 20 minutes, you don't know what you're talking about.
I think we exceeded.
Does that go for the legal staff as well?
But what happens is, and I can tell you from a chairman's point of view is I don't want to set ourselves up for an appeal based on that I didn't listen to all the sufficient evidence. So sometimes I do let it extend a little bit further than what we would normally like. That way I give them the opportunities. In other words, you've had ample time to state your case, and I don't want to have to come back and rehear it because he appealed it, and it's gonna go through all over again. The specific case you're talking about is, and this was my point when I was saying it is, that was the third time we've heard the case. I didn't
Yes.
want any additional evidence other than what new evidence, and we heard it anyway. So where do you draw the line?
Well,
I guarantee you that if I had cut him off a third of the way through, we'd have got an appeal, and we'd have been hearing that case again.
You mean the guy with the, yeah.
well, here's my situation is that it
You were-
it wasn't new material being presented. It was, and in the same 30-minute span, I think it was probably exceeded that, we heard the same material 2 and 3 times over and over and over again. And what got me was at the very tail end, when we started reading scripture, I'm thinking, what is the relevance to
Right.
what's in front of us? And this is where it's time to, if you presented all your material, we're done. We don't, I mean, I frankly, I thought about getting up and just walking out at that point. And I think that may be my course of action in the future, because I don't need to get a sermon when we're talking about zoning and quasi-judicial items.
Exactly. I agree. And I made note of that to him, and the response was,
Oh, I
he
heard it.
had.
I heard it.
And Mr. Chair, I can provide
Constitutional
this
right.
board the draft language for the quasi-judicial proceedings. I think I'm going to present it before council on the September 6th meeting for discussion to see where they want to direct me. I'll provide it to this board for comments. I still have time to make any changes that you would like, because it would also apply to all quasi-judicial boards. And there's no set time frame for applicant presentations, but I do state that the chair can limit the applicant to a reasonable time. And usually that reasonable time is no more than 20 minutes, because it shouldn't take that long to present it.
Well, I'd like to see something in black and white that I can do that.
Absolutely.
Because otherwise, I'm sitting here trying to defend someone that defend myself for cutting someone else off short of what they feel wasn't long enough, or they feel we know what was going on there. Everybody did know what was going on there. So, I mean, it's, you know, it was
week to
ridiculous.
get
There's
COVID.
no- But you know what? At the end of the day, we got it through, did we not? That's the bottom line.
We usually give the presenter an opportunity to come rebut. Do you
Yes.
have language in there?
Yes,
that-
yes. So there's an order of presentation, which mimics what you've been doing. So usually it's ex parte, staff presents, applicant presents, then you have public comment, then you have the ability for rebuttal, then you close public comment, then you're in discussion, and then motion and a vote. Right, that's a standard quasi-judicial process, and I just kind of codified that so that here's the rules. If you walk in, here's what you're going to expect. And if you are an applicant, the chair can limit your time to avoid repetitious, unhelpful statements that don't meet. Remember, your decisions need to be based on substantial evidence, and you can discard testimony that don't meet that standard, or you can direct the applicant, I need evidence.
Well, I tried to set it up at the beginning of the meeting, and then I even mentioned it during the meeting, and, so. Other than pushing the button and having it removed, I don't know what else I could have done.
If I could make a suggestion, since you're writing those procedures, I mean, if we limit, say, 20 minutes on the presentation, but the situation that occurred was not on the presentation, it was on the rebuttal side. So in my opinion, and this is strictly my opinion, that a rebuttal should be limited to the same 3-minute timeline that the public speakers were given. So you should be able to rebut in 3 minutes, not regurgitate 20 minutes of presentation.
Because that's the exact same time I provide. Yes, and it's also
I'm a mind reader.
It's also limited to rebutting what was actually said. You can't bring up new evidence. So the rebuttal is narrow scope.
Then we're all on the same. I'm on the same page with you.
Okay,
then.
got it. Well, it helps us. It helps me out sitting in this chair. Okay. Any other commission comment? I'd like to make a comment. I want to publicly apologize to Mr. Bender for bringing those variances out of order. There was never any shenanigans ever thought about doing, and I do apologize for that. I did not know that you would have thought of it that way. And there again, we'll try to do better, okay? All right. All right, any press and citizen comments? This meeting is adjourned.
We have to sign it.